Yes. May I please, Your Lordship? Yes.
With the consent of other side, my lord, I beg to mention item number 14, my lord.
1-4.
My lord.
You are for?
I am 14, my lord. Petitioner, my lord.
Okay.
I am for respondent number 2.
Maintenance is being paid.
My lord, that instructions, my lord, I will have to take because I have been newly engaged, my lord.
Because stay is so far relating to 20,000 only.
I have checked it, my lord.
Are they paying regularly?
No.
Wait. Wait for something.
My lord, that,
Have your instruction. Or we'll vacate the stay.
my lord, on second, my lord. Because I have some difficulty today, my lord. On second, my lord.
The learned counsel for the petitioner seeks an adjournment in this case. The matter pertains to challenge to an order passed under section 125 CRPC in favor of the wife. An amount of rupees 4,000 was awarded as monthly maintenance and an amount of rupees 20,000 was awarded as
Compensation.
compensation. This court, while issuing notice of motion, stayed the payment, the order so far relating to the payment of compensation. However, subject to a condition that the petitioner shall regularly pay the maintenance amount awarded, that is rupees 4,000 per month. The learned counsel for the respondent submits that such payment are also not been regularly made. If such payments are such statements are correct, this court may pass order which may be necessary for implementation of the order, inasmuch as the matter pertains to payment of maintenance to one wife. At this stage, Mr. Sharma, learned counsel, submits that he has newly been engaged, so therefore he will obtain instruction in this regard and in this regard whether the petitioner has been paying the maintenance. Place this matter on second.
Highly applied.
May it please your lordship. Lordship, I beg to mention for listing of a criminal petition, lordship.
Hmm.
Next week, any date, lordship.
Next, it may not be possible. Mosumi,
Wednesday, Thursday.
7th of May.
I
7th is holiday. 8th of May.
can it be lordship on next week? Any-
Next week not possible. We have already fixed many matters. Not possible. Give a date thereafter. 8th of May. Yes.
May I please, Your Lordship? Your Lordship, I would like to mention for listing of an criminal revision, Your Lordship. After election, any date, Your Lordship.
Give a date after 9th of May. Yes, 9th of May.
Oblige, Your Lordship.
May it please your lordship. I beg to mention item 46. Learned additional AG has some personal difficulty, lordship. A matter may be listed next week, lordship.
What was this?
Additional AG was appointed as amicus,
MS.
lordship.
Okay. Who was for the petitioner? Okay, well, let John, have you informed the petitioner?
Yes, lord.
Inform, okay. It is submitted that Mr. P.N. Goswami, learned amicus, is having some difficulty today. Accordingly, matter stands adjourned and be listed,
Any date next week, lordship.
not next week, thereafter. 18th of May,
May I please?
17th of May. Yes.
May I please lordships. So one criminal petition matter, my lord, for quashing the my lord FIR, my lord. Admission matter amicably settled in between the parties, my lord. On Monday, my lord, if possible, my lord.
What
Yes,
was the offense?
376, my lord. Both of them attained majority, my lord. Thereafter, my lord, amicably settled, and they are
76 also can be amicably settled.
yes. My lord, admission matter, my lord, both
Not next week, thereafter.
on Monday, my lord. It was
Not Monday, no. 13th of May.
10th.
13th of
Obliged, my lord. Much obliged.
Maybe, Lordship, I would like to mention item number 17, maybe adjourn, senior is out of station.
Item number?
17.
Yes,
CD is available, lordship.
CD is available. It's a bail application.
Yes.
Wait. Yes.
May it please your lordship. Lordship, today's daily list item number 21.
Lordship, we have filed one additional affidavit, so
Mm.
kindly the same may be called for.
Yes,
Lordship. May it please, my lord. Item number 19, my lord, 19. I have inquired, my lord, updated case diary is not been received, my lord.
yes.
Another,
Shift.
another
When?
day.
Lordship, in the month of May, 10 May,
10th of May. In any interim?
Interim is there.
Interim to continue.
Obliged.
I recommend item number 44, my lord. This matter has come for orders, my lord. We are on stay. This is a closing petition, my lord.
Huh?
So, closing petition.
Yes.
Let me fix for hearing, my lord. Opposite party has appeared already, my lord.
So you want a matter to be fixed for hearing in the monsoon stage? Without knowing what is what? Rejected. Yes, next case.
May it please your lordship.
Yes.
My lord, I mentioned for listing a bail application.
Hmm.
My lord, file on 22/4, my lord. Maybe taken up tomorrow, my lord.
BA.
My lord, be highly obliged, your lord.
May I please, your lordship. Your lordship, I beg to mention item number 24, your lordship. CD was called for, but CD is not available.
not received, Lordship.
Any interim?
Interim is there, your lordship.
When?
Lordship, 17 May.
17th. Interim. to-
Highly obliged, your lordship.
May it please your lordship.
Yes.
Lordship, I beg to mention for listing a criminal appeal, lordship,
Mm.
for admission, lordship, on next week, lordship.
First time.
No, lordship, admission matter.
Admission means first time.
No. Earlier it was taken up once on 6th of November.
Admission, appeal, criminal appeal, yes, list.
On next week, lordship.
Yes.
Obliged, lordship.
Should be number 1.
May I please, your lordship?
TD. When?
Lordship, 10th of May.
10th of May.
Lordship, can it be on 6th?
Ask him.
Be on 6th only.
6th.
Election will be there, Lordship.
Already 36 days, he is behind the bar.
So 90 days offense, Lordship. Fake
We know
currency.
that. That's why we call for the case. Fake currency.
9th,
Take a risk. Without CD, these cases will be difficult. So if you want take us on 6, if it is not come,
8th, Lordship.
yeah, 7th is an election.
That is
When are you saying?
11.
On
8 or 9, Lordship.
8 or 11th?
11.
10th, 10th,
10,
10th, 10th.
10.
Yes.
May I
CD,
please, your lordship, my lord, this
CD,
call
CD.
for the CD along with the postmortem report. After my lord election.
Lordship,
Second week of May, my lord.
13th of May, Lordship.
13th.
My lord, this another matter, item 22 is already charged.
Wait for it. Can you take matters like this? Everybody is busy or what? You are so busy that you cannot wait till 2022. There is a decorum, yes. CD,
Acquisition 302, lords, along with the PM report. Lord.
PM report.
14th of May, Lordship.
Yes.
Maybe item 4.
May I please, your lordship? FIR, my lord, kindly seek is 10, my lord.
Hmm. If you are a minor, how can they arrest you? Will not arrest you. Are you a minor?
Charging me, my lord.
Huh?
I'm a student, my lord.
Yes, sir. PP, what to do? He admittedly is a minor. Police cannot arrest. And there cannot be any apprehension. And
Charging
will
me,
take action if it is arrested. That is for sure.
charging me to arrest me, sir.
Okay. Juvenile board
Give a direction, my lord.
will not give any direction. Will obtain instruction. We are not calling for the case there. The petitioner. Need to live a decision application under suspension. The petitioner claims to be a juvenile and in support of such contention, admit card issued by Board of Secondary Education Assam is annexed along with the petition, which shows the date of birth is of the petitioner is 31/12/2007. Full stop. In that view of the matter, and if the same is correct, the petitioner cannot be put behind bar in terms of the Juvenile Justice Care and Protection Act. Therefore, the learned public prosecutor shall obtain instruction whether police is searching for to arrest the present petitioner which is stated to be juvenile. Full stop. Please this method day after tomorrow. So tomorrow, 2 days, tomorrow, Friday. You have it, this instruction, we'll dispose it of tomorrow. Yes,
Same FIR, my lord.
same FIR.
Yes, sir.
Let us take this method tomorrow. Apparently seems that these both are minor.
No, both no matter.
Huh?
It's not matter.
No, is not. The victim and the accused,
And
both
whether,
are minor.
and whether the girl has been recovered or not, Lordship.
Recovered, yes.
Girl has been recovered, they made a
Recovered, madam.
statement. And other issue is that most probably families are apparently reading, it seems. So we are fixing it tomorrow in the,
For instance,
for instruction. You have this. Unnecessarily, people should not be behind.
Okay.
It seems from the affair. You have the instruction.
Okay.
Yes.
438 application, my lord, FIR, my lord, page 8. Petitioner number 2 and 3, their names shown differently, my lord. Rafiqul Ali and Rafiqul Ali. Even they are the Hussein, my lord, Rafiqul Hussein and Safiqul Hussein. And petitioner 1 was an old man, my lord. He cannot. attack the person. And regarding the land dispute, my lord, and petitioner number 1 himself was seriously injured and immediately he was brought to the hospital. And he is still under treatment, my lord.
Have you lost any affair?
But he could not able to lodge the affair. In the meantime, this present case is lost. My lord.
You are Sofiq, you are
My lord,
Sattar.
petitioner, my lord, 1 is Sattar, my lord, age about 65 years. And he was admitted, my lord, at Fakhruddin Ali Ahmed Hospital.
Where is that admission record?
This is page, my lord, 15. Sattar Ali, 65 years, 6 AM. And so many, my lord, examination was held, my lord, X-ray, CT, CT scan, and so many things, my lord. And he is still, my lord, under treatment. About 65 years, says my lord.
Lordship, in the,
And eventually, my lord, it was a land dispute, and the informant tried to, my lord, to take possession by way of banana plantation to the khas land of the petitioner. Now, since this incident happened, my lord, and petitioner number 2 and 3 was not present on the spot. And they are not also, my lord,
Where is the affair?
FIR, my lord, page 8. Allegation, my lord, the petition number 1, assaulted by wood cutter machine. How it can be possible?
Where is your report? Because as per your report, nothing is there.
yes.
That's why I'm searching. Where is your report? That X-ray report and all.
No, that is, that has not.
That why
furnished-
have you, why have you
I will
withdrawn
furnish, my
that?
lord.
Huh? Why have you withdrawn that?
I will furnish all
Only
the-
soft tissue injury.
I will furnish all the medical report, my lord. I have
Because orthopedics report says nothing.
X-ray report, CT scan, everything I have, my lord. I'll furnish. Lord, my lord, short date may be given till returnable date, my lord. Protection may be given, my lord.
To accuse Sattar Ali, huh? CD interim to Sattar Ali,
Highly obliged.
not to others. CD on
Lordship, 13 May.
13.
I look.
Malada PRS, page 13, FIR. Admitted fact, there is an incident happened, Malad. But I have a grocery shop in the locality and everybody is implicated in the FIR, Malad. 23%. I have a grocery shop.
That is the difficulty. Why you take your?
Malad, I have a grocery shop in that area. And I have a business.
We'll examine city.
Malad, some interim because
Difficult. This will open
some
the
are
floodgate.
arrested, but main persons are arrested,
Do
but
not appreciate this kind of allegation.
my lord, all persons in the locality has been involved. I have a
We'll see
grocery,
that from them.
but I have a grocery shop, my kids and there, my lord, family is there, my lord, some protection, my lord, I'm having not keeping well also. My lord. Some protection.
Keeping not well, don't argue because your
I understand, my lord.
medical documents, these are
Some,
nothing.
my lord, some.
Okay. Give a date.
14.
Obliged me.
May I please, your lordship?
Necessary allegation. Particular.
May I please, your
Yes.
lordship? 438 application, lordship. The petitioner is a 26-year lady, lordship.
Hmm.
She is working as zonal manager at Manav Kalyan Nidhi Limited. Their business is that they provide some loan
We'll
to the
examine.
petty business, lordship. I may be allowed to appear. I have all the documents.
14.5.
Some protection may kindly be given.
Specifically name how you have done it, everything is there. Yes.
Motion item number 9.
Hard.
Yeah.
The learned counsel for the petitioner. The present application. 397,401, we cannot interfere this order.
Other, my lord, because
We cannot. It's a statutory provision. Until and unless 482 power is exercised, we cannot pass an order interfering.
next time, my lord, I will be careful.
Huh?
Lordship, next time, my lord, some typographical mistake because of,
Isn't it?
next time I will be careful.
Be careful this time. Also, learned counsel for the petitioner submits that there is some mistake in filing this application. Accordingly, he prays to withdraw this application to file an fresh application. Prayer is allowed. We are becoming so casual. Therefore, these are the issues. Can we interfere with an order which has been passed in terms of a statutory provision?
This is, my lord, illegality, the Supreme Court said that is not.
Supreme Court says in case of bail. So whether that principle can be applied to a statutory provision
No,
can be made in 482, not in 397.
no, no, this is their order. Supreme Court says imposing of such condition, this is not. Therefore, I have challenged the
So
legal.
therefore, can we pass an order? That order we can pass under 482, not under. This is passed under what provision? Supreme Court?
Supreme Court, this is, my lord,
Under what provision? Tell us.
IAN number Iman. SB
Withdrawal or
criminal
dismissal?
MP.
Withdrawal or dismissal, not being not maintainable. With a liberty to file a court. Too casual we are. Therefore, this is the result. We will be strict. Yes, next case.
Same.
Same. Otherwise, we are supposed to give you relief or consider all this. Item?
My lord, in that case, my lord, original certificate will may be read.
Huh?
Certificate.
The certified copy registry to return back the certified copy to the petitioner. Certified copy of the impugned order to the petitioner.
Kindly passed over Lordship sometime.
Hmm?
Let me passed over for some time.
Is here. Where is the order of cognizance?
My lord,
Where is the order of cognizance?
order of, yes, my lord, that order is not as a part
If
of. the
that
record.
order is not there, that is under silence, how do you know it is rightly taken, wrongly taken?
My lord, my lord. May I call for the records, my lord?
No.
But by,
You are, no, Mr. We are, mayor asking call for the record, will call for the record in a criminal proceeding.
I have to satisfy my lord.
Yes, then,
My lord, bring those on by of an addition.
okay. Mr. Here, we are learned counsel for the petitioner, submits that he may be granted.
Oh.
When?
My
When?
lord, 10 days.
10 days time to file an additional affidavit to bring on record the order dated. Order dated?
Mention here, my lord.
Hmm?
The order is also not mentioned. My lord, I
What
may be
kind
allowed,
of
my lord, I may be allowed to withdraw with
What
the
kind
record,
of
file a
petition?
fresh, my lord.
Submits that he may be allowed to withdraw the present petition and to file a fresh petition as the certain important
My lord.
the orders slash documents are not annexed. Prayer is allowed. Accordingly, this petition stands closed on withdrawal with a liberty as preferred.
Fine.
Yes, yes, yes.
Obliged, my lord. My pleasure, lordship. I'm
Yes.
preparing for the state lordship. Came to the lens.
Okay.
Notice me, please.
What was the order on last?
Yesterday also.
Yesterday?
Notice was.
Notice me. This is an application under order exactly same. Which was the item number? Give the item.
12. Yesterday, lordship. I'll give,
Yesterday.
I'll sub. Obliged.
16.
Yes.
It is on page 7, lordship, 71 days.
Item number 16, my lord, case diary not received.
What is the allegation?
Allegation is under 302. lordship.
302.
FIR,
FIR is on page 7, lordship.
page 7.
Yes, lordship. The original one is on page 11, lordship.
When can you have 71 days only?
Any sort of immediately after on 9th of
9th.
9th.
Obliged.
17.
May I please, your
Who is the FIR?
9 to 11. man.
Huh?
That's not 9 to 11.
17.
9.
9 to 11. man.
17 may kindly for the time being, madam. Sharma has gone through the.
Okay.
18.
18 also, my lord, case diary not received, madam.
Who is the FIR?
Page 14, lord.
Oh, that case.
89 days, my lord, as on.
89.
My lord,
Have the information
yes,
where the
ma'am, I'll
search sheet
get
is
that
filed.
information, yes,
Huh?
ma'am.
If not, we'll allow it today.
Yes.
Yes.
56 to 7, my lord.
May I please, your lordship?
Yes.
Lordship, 57 days behind the bar.
Where is the FIR?
FIR is a page 10 translated copy.
This is her statement.
Charge sheeted. Search, being search sheet number?
No, my lord, already my lord scan copy call for my.
Okay, this is already search sheeted case.
Yes,
Scan
sir.
copy is there?
Yes, my lord.
Have you gone through?
Lordship. Yes, ma'am.
Where is the scan copy?
Lordship, it is item number 56, Hakim Ali.
56.
CD was followed.
Sheet is there? Okay. How many days?
57 days, Lordship, as of today.
It's not search sheeted case.
No, my lord, I am thinking of another case.
Let him go.
Yes, but my lord, I leave it to lordship, but lordship may kindly peruse the medical
Consent, it seems
consent
consent.
team, but lordship may kindly peruse the medical report. He is not a person.
Usually, other people who approach
Medical
us.
report has come, my lord. Earlier it has not come, my lord. He was forcefully taken and severely assaulted, my lord. Now, my lord, she is want to get rid of the my lord, accused, my lord, but he is not leaving her, my lord.
Actually, Lordship, the petitioner
And he
wanted
also
to marry. the
Habitual, my lord.
permissive.
Another case also been filed against him, my lord. Has many as 7 injuries, my lord.
What is your statement?
Statement 164 is there, my lord. There might be some relationships, it is, might be true, my lord, but after
But
that, my
the
lord,
relationship will not permit a
But-
person to
yes,
injure somebody like
Yes.
this.
now
I
she,
thought that this was a
yes,
on the
yes,
on the appearance of the FIR,
yes,
but
yes, yes. They work in the same organization after that, my lord, but now, my lord,
what is the statement?
yeah, I have flag mark, my lord, 164 there. From the last, yes,
Hmm.
there are 2 cases, my lord, given by. Thank you.
Earlier also he
Earlier also, my lord, one
already a case was
case is
pending.
pending against him, my lord, and my lord, as per her statement, to my withdraw that case, he was again beaten up and forcefully raped, my lord.
Do you require his further custody?
I think that, my lord,
Apparently almost complete investigation. Why they don't file?
my lord, going by the gravity of the offense and also, my lord,
There is a scope,
there is scope,
scope,
my lord,
there is a scope.
because his conduct, my lord, perhaps.
Be there for something.
Lordship, kindly, it may be considered at this stage. Lordship, earlier also the case, she lodged an
Oh, we
FIR.
understand, but her everything, we would not have believed her statement. What about the injury? We would not have believed that this is a consenting, she has falsely given, but what about the injury? Exactly, that she described, that is the injury.
That is the injury.
Let the report come, FSL report.
Yeah.
Regarding other evidences. Then
So, my lord, it may be disposed of at this stage, my lord. Because it is.
today is 76.
No, my lord, 50,
7
only
days.
56, 90 days. only.
considered the materials available, including the injury report, which fortifies the allegation of the petitioner. The stage of investigation do not warrant uh, release of the petitioner on bail, inasmuch as the conduct of the petitioner shows that conduct of the petitioner also fortifies the apprehension of the investigating officer that petitioner may once again attack the victim. Huh? Yes. Next case.
Nice. May I please join her?
Yes,
One copy call for and receive, madam.
received. What is the allegation here?
Allegation is it's 302, Your Honor.
302.
Two, madam.
Who died?
Madam, the scan copy may kindly produce, madam. The PM is there and also now, madam, 10 witness already examined, madam. And it's and
This is the son of the accused.
This is the son of
son
the
of the-
accused.
that is the most tragic part, madam.
Why he was
And-
killed? Where is the FIR?
Your Honor, in page number 11, the informant is the daughter-in-law of the accused.
Informant is the daughter-in-law of the accused.
Today evening at about 4 p.m., my husband, namely Pinanda Arandhara, was killed by my father-in-law, Sri Dilip Arandhara, and mother-in-law, Srimati Joya Arandhara, in my bedroom of our house by strangulation by a gamusa. During the incident, I was shouted from outside the room because my in-laws were killed my husband by locking the door from inside by pushing me outside the room. The entire incident was seen by my own daughter, namely Srimati Dixita Arandhara, by a window. The neighbors who came after they heard hue and cry and tried to open the locked door from outside, where the incident took place. After some time, they opened the door from inside, but already my husband was dead. Your Honor, kindly go in the page number 35.
Oh, yes.
Page number?
35.
Where is this?
This is the charge sheet, Your Honor. May I, Your Honor?
The daughter is examined?
And also may kindly go to page number 51 of the petition, madam.
PW, daughter?
PW is
Three.
three, madam.
Daughter is PW3.
Yes, Your Honor.
Who is the wife?
Very pathetic, madam. Sinek kindly
Reaffirm by the side witness.
Your Honor, kindly go to page number 35.
cannot be.
Yes,
Page number 35, Your Honor.
yes. 31.
35. This is the charge sheet, Your Honor.
Hmm.
In course of investigation, the informant Srimati Priyanka Arandhara submitted a letter stated that under pressure, she was identified the dead body as Binanda Arandhara at the time of inquest.
Hmm.
But actually her husband name was Ananta Arandhara.
Hmm.
And
Then
the deceased Ananta Arandhara has one younger brother.
Hmm.
And
who is
if-
serving the
Yes.
police force in the
Yes,
name
yes,
of
Your Honor.
this person,
in the name of
the
deceased
deceased person.
certificates.
But this
UPS.
was the issue because job is in somebody else's name and
Yes,
is served by somebody else. So who will get the salary? That is the issue.
That is,
Forget about others.
that is it.
Can that be a ground to grant you bail when the child has reaffirmed in cross-examination?
Sinek kindly imagine, my lord, he is shouting from the window, my lord, not to kill her father.
Hard. Swensu. Want to withdraw or we comment on the materials?
Again of the my lord trial because 10 witness already.
Because we'll have to deal with the evidences.
Hmm.
Who says what and why you have rejected.
Better to withdraw.
The matter is in evidence stages. In fact, no?
Yeah, board.
Yes.
After few days, it is sure to that you will have to go inside. Want to withdraw or will dictate the order?
Withdraw it.
Withdraw. A learned counsel for the. Because ultimately, even in the stage of appeal, this order may affect you.
And
At least mind, even if we give that observation that
Yes.
it should not influence, but that may influence.
yes.
Wants to withdraw this application and at this stage, accordingly, prayer is allowed. This in application, yes.
Timing at 17. Let's run.
Yes.
On behalf of Anne Islam,
Hmm.
my senior counsel is out of station, my lord.
Yes, okay. Yes, there is yes.
Yes, Lordship, case there is here.
What is the allegation?
Here allegation, Lordship,
498 basis.
fake currency were recovered from Lordship, certain persons, Lordship, they were arrested.
Hmm.
Subsequently, Lordship, this petitioner was arrested.
Hmm.
And after his interrogation, he named one more co-accused, Lordship, that is Mizanur Rahman,
Hmm.
as being the co-accused who had supplied those notes, Lordship. And when this Mizanur Rahman's house was searched, Lordship, from his possession, 40,000 fake currency notes were recovered, Lordship. Now, Lordship, in the instant case, around 5 persons has so far been arrested and 2 or 3 persons are still absconding, Lordship.
How many days they are behind bar?
In
48
custody
days.
is 48 days and Lordship, one more seizure was made, Lordship. There, Lordship, around 1 crore 37 lakhs was recovered. So, Lordship, this is a huge racket that is operating and he is interrogated.
If you want to be inside, we are giving a long date.
Lordship,
When?
The 2 April.
Give a date so that you can return back.
yes.
Learned counsel for the petitioner submits that he is having some difficulty today, accordingly press for an adjournment. Full stop. On the other hand, learned counsel, learned additional public prosecutor has submitted that he has received the case diary. Full stop. Considering the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on
27th May.
27th of May 2024. Case diary be returned back for further investigation and be produced on the next date of closing.
18 timing members.
Well, 18 as per my charge sheet not yet submitted.
Not yet submitted, considering the stage of investigation in as much as the petitioner,
Yes.
not stage of investigation, considering the period of detention. Periods of detention, the present petition is allowed
Yes.
only considered
89
periods.
days.
In as much support petitioner has been, the petitioner has been in custody for last 89 days. Full stop. Considering the period of detention and the fact that charge sheet has not yet been filed,
Yes.
the present application stands allowed. To the satisfaction of? Huh? To the satisfaction of me? Or you?
My lord, CJM Dima Hassan.
No, how can I? You will have to say. Can I say to the satisfaction of Kamrup Metro?
As regards amount, blood.
No, not amount. I am saying to the satisfaction. Yes. Yes, Mr. Doctor.
My lord, it's a rejected bail earlier, my lord.
Why?
Up to date case diary was called for, my lord. Earlier rejection was of, my lord, 16/10/23.
Where is that order?
My lord, the order your lordship will find
This
at
is the
page
later one.
27.
Yes, 27.
27. 28 the operating point. Now your lordship may turn to page 22. Fourth
Right.
paragraph, my lord. The brief facts of the case, lordship found. Page 22. It's a belag manu. It's a belag manu.
Oh, that 302.
Yes, my lord, that those now next page, my lord, only one paragraph, my lord, I'm pointing out, I don't know what. Perusal of the case diary reveals that the accused person so and so, my lord. It further appears that the CD, that the IO has failed to collect sufficient incriminating material, my lord. But so far I
But we
understand, my
have
lord.
seen incriminating material.
My lord, so far I understand, my lord, one thief was apprehended, my lord. The public has given some, my lord.
Rejected.
No.
Difficult. I have seen this case diary.
Only the
These
petitioner-
people who has taken their that law to unto their hands and killed a person, in my considered opinion, is not entitled for privilege of PRS bail.
The petitioner number one
Yes,
is
sir.
the, my lord, is a bachelor of engineering. I'll leave it to lord.
Second bail application, rejection order.
21 to BC.
My lords, I am appearing on behalf of the complainant in 21, my lords.
Yes.
May I please, your lordship?
Yes.
Lordship, 430th application. Lordship, I'm in interim while order dated 6/2/24. Lordship, subsequent to that, I had made my appearances on various dates. Lordship, I prepared a chart for the appearances that I've made.
Yes, now?
So, Lordship, I've been cooperating with the investigation.
Yes, what you say? What is the case in the case diary?
My lord, my senior appears.
My lords, case diary, I do not have, a, but
PP, we'll hear you later on.
yes.
Okay.
My lord, case diary received, my lord. Here there are 4 accused persons, my lord. Regarding, my lord, all the accused persons, my lord, already appeared before their statement recorded, my lord. And regarding the, my lord, main allegation is actually, my lord,
Cancellation and siphoning of the money.
yes.
Last moment cancelling the ticket and
Yes, my
siphoning of the money.
Yes, my lord, that is true, my lord. There are, my lord, note of the specific note of the IO. Your lordship may kindly peruse, my lord. And
Why custodial interrogation is required?
Exactly, Lordship. Lordship, another thing I want to point it out is, Lordship, the tickets have been purchased by a supplier. I'm just the middleman. So the discretion for cancelling the tickets will lie with the supplier. It's not in my hands, Lordship.
No, that will not
And
comment,
also
that
the-
will not comment, that may be your modus operandi to cancel and siphon of the money.
Lordship, just
But
coming to
if
the merits of
after
the
an
case.
interim order, what kind of interrogation is required, that we'll see from the case diary, that's all. It is nobody's satisfaction that somebody should go to jail. We'll see whether any custodial interrogation is required.
Lordship.
So if it's gonna be such action, not this. Maybe that's it.
My lord, I also believe state filed some objections. I've been informed by the local council in the morning. I believe, my lord, state have filed an objections. I've been informed by the local council.
No objection is filed. Any objection filed?
No, written
It's-
No
objection I
written
have not
objection.
filed.
I had filed an additional.
My lord, I will just like to point out, my lord, regarding other issues, regarding the your lordship has already gone through the my lord, note of the IO and the case there. My lord, what happened, my lord, initially, my lord, yes, there is an agreement between the my lord, admittedly, my lord, that my lord, his my lord, what happened, my lord, suppose my lord, my lord, purchase a ticket from a.
We understand. Their case is that you have purchased
Yes, my lord.
ticket last, it amounts of some 23 lakhs or something. They have last moment when the passenger was at the airport, tickets were cancelled.
Yes.
And this informant, according to them, they have done their part in giving a fresh ticket to those customers to for the reputation of their business. This is the allegation.
Yes, ma'am.
And this is sitting and all. Now,
Lordship, in fact, that tickets have been provided by us only.
interim protection was granted. Their statements are recorded. Investigation shows that they appeared 2-3 times.
Okay.
Record says. And they were called. They have cooperated. Why interrogation is required that much? Let me have a satisfaction. Whoever objects.
My lords, I have objections. May I raise the objections, my lords? First objections, my lord, if my lord may see order dated 4/3/2024, passed by this court, where the case diary reflected that certain documents were sought from them, and those documents were not produced. And then this court granted them liberty to produce documents. After that, I was called to the police station to be confronted with the accused. Accused did not turn up on that occasion, my lords. And in my knowledge, my lords, he was issued 41A notice on that particular day. After 41A notice also, he did not appear, my lords. And what has happened, that while he is out, my lords, he is siphoning off the funds from one bank to another. In my understanding, my lords, on last occasion, status report was there was something, bank account details given showing 1,000, when these documents were produced by him, bank account details were showing some 1,000 rupees, though the amount involved in this case is of 2 crore rupees, my lords, and section 409 is being imposed. And the issue is not only, my lords, tickets being cancelled at last moment. The core and thrust of this matter is, my lords, he induced me that he has certain discounts. I believe during investigation it would have come out that he had never, at no point, had any discounts to be given. So the offense of 409 and 420 is clearly made out. Now, as of today, he's not even found at this place of residence, my lords. And if you see his paragraph number 6, 7, there are 70, 80 tickets involved. Not a single reason given other than saying it as a technical glitch. So he's not even answering what can be the reason for 70, 80 tickets being violated. Next point, my lords. Between 2019 to 2023 to February 2024, total of 2 crore rupees of ticket, total loss cost and wrongful gain to him, my lords. And in this whole process, some of his other companies are also involved, my lords, where the money is being siphoned off. That would also have come in investigation by Nord, my lords, where the money is being siphoned. So it's not a simple case where he's just siphoned off. And there are other companies who had approached us have not filed a complaint till now. And there are other companies also cheated with him because there are 70, 80 tickets that has been cancelled. Other thing, my lords, he's at a flight risk because at presently he's not found at his place. Second thing, my lord, he's from travel industry. It's like very easy for him to escape, my lords, and go. He's not cooperating after having interim order from this court. What will
Can
he
we see
do?
from the record whether cooperating statements are
Yes.
recorded? What are the issues? We'll see.
And my lord, with respect to the law, if Siddharam Maitre and Union of India Padam Nigam Chidambaram, very clear, my lords, AB is an exception. May I hand over a few judgments, my lords, in this regard? Union of India versus Padam Narayan, my lords, para 24.
Give your judgments. Yes, what you say?
My lord, I would like to point out, my lord. Yes, regarding my lord, there are 4 accused persons, my lord. Why, my lord? Oh, yes, after obtaining interim, the accused persons, all the accused persons appeared, statement recorded. So now only because, my lord, accused persons appeared, because regarding other accused person, my lord, I have no objection. Only regarding accused number 1, my lord, at this point of time, my lord.
Why?
Because, my lord, he has appeared, statement recorded. That cannot be a ground that his further custodial interrogation is not necessary, my lord. Because, my lord, here from
What is the offense, by the way?
My lord, offense, my lord, what happened, my lord, although initially, my lord, I thought, my lord, from the contents of the FIR, I initially, my lord, thought that this is a simple case, my lord, because of some technical glitch, 1 ticket, my lord.
Forget about technical. That he has done it intentionally.
Yes, my lord.
Yes.
Later on, if, my lord, suppose, my lord, yesterday, my lord, tomorrow I booked a ticket before 1 month, my lord, for, my lord, for traveling to.
No, that is a very
At
inconvenience
the
to a
last point
person.
of time, yes,
There's no
this
doubt
is not
about
only
that.
a case of one
No
single
doubt about that.
passenger, my
No
lord.
doubt about that.
And because this kind of continuously going on, this is not only in case of a one single offense, my lord. That note of the IO is very
Now
specific.
tell us, can you assure that this kind of things will not be happen anywhere?
Yes, my lord, going on, but my lord,
What do you mean
for
by Vistara, Spice
for
Gate?
which,
Please take your.
for which,
I'm
my lord, for which, my lord, this kind of offenses need to be stopped, my lord.
Is it your case that that we have not been able to unearth? Suppose you unearth. I'm not getting it, Mr. Bhottakur. I'm a little bit surprised.
Yes, my lord.
We'll see each and every page of the case diary.
Yes, my lord.
But seems
Otherwise,
like
I will, my lord, raise my objection. Otherwise, I will leave it to your lordship.
no, don't leave it to us. Leaving it to us is difficult.
Yes, because my lord already.
We'll apply our mind, no doubt about that.
Yes, my lord.
But just we'll hear everybody.
Because my
We'll see the judgments also in 438.
because
No problem on that.
because my lord, suppose my lord, now the in
Don't say suppose. Say that these are the materials why I need a controversy.
one material is, my lord, it is clear that in case of one passenger, that type of, my lord, offense was committed by the accused person. But from the case diary, my lord, it reflects that note of the IO, that not only in case of one passenger, there are many passengers. It is specifically mentioned about 70, 80, but that record is regarding 70, 80. Till now, investigation is going on. My lord, more than, my lord, 10 passengers. That record is available. In
How many days you want to complete the investigation?
My lord, definitely, my lord, in this kind of fraud, my lord, techniques of, my lord, committing this type of fraud.
Here is no technique is required. They have cancelled and taken the money
My lord,
and compel the other person to give a ticket to maintain his prestige. This is the allegation. Last moment, I bought a ticket from you. Okay, you promised me that this will be a huge benefit of the ticket I have already purchased from the airlines. So buy it from me. I buy it from me and I sell it to her. She is my direct customer.
Direct customer, yes, my lord.
So at last moment, you cancel the ticket.
Yes.
What should I do? So to maintain a relation, I again book the ticket and with my, at my cost and at my loss, I have asked her.
I'm sorry, my lord. May I just add very crucial point in this? What is the core of the matter? I'm really sorry, my lords. I'm interrupting, my lords. But the core of the matter is why this whole transaction with the accused started, because accused induced that he has certain discounts, and on basis of those
That is
certain
what I'm saying.
discounts,
That discounts is
yes,
being given. That is saying that
and
he
those
promised that
discounts
I'll
are
give you.
not available with him. So, moment discounts are not available with him, he had always the
So he had
intention
the initial intention. The
to, yes,
intention is in his mind.
yes.
Is not it?
So, and
So what
that comes,
kind
my
of
lords,
interrogation do
409
you
also.
need to do
409
that?
also,
That
my lords,
materials
comes into
record
picture.
is sufficient.
My lords,
That
the
these tickets are
investigation is
booked.
not complete. He is not
Just
coming
let me
forward.
submit one
So
point, my
that's
lord.
the
Otherwise,
problem,
you
my
will
lords.
decide, my lord.
Mr.
Suppose, my lord-
Bhattakur, we are giving too much of time in this case.
sorry, my lord.
And my lords, investigation. One more thing, my lords. The interim in this case was granted without hearing me on last occasion. I moved two applications: application for vacation of stay and application for imprisonment. When this interim was granted, I was not heard at point of time. So the last order also reflect that at
See,
all
Mr.
point I
Counsel,
appeared.
Mr. Counsel,
Yes.
you are assisting the public prosecutor only. Number
No, my
one.
lords, I've been given a permission to
No,
audience,
I
my
have
lords, by
given you
last order.
permission. That's why I am giving you a patient hearing. First.
Yes, sir.
Second issue is that we'll determine whether this is a case of 438 on the basis of materials available on record.
Grateful,
Not beyond that. If we
my
think
lords,
that
just
this
then
is a
respectfully
case where custodial intervention is necessary, the earlier interim order will not debar us to recall the
yes,
order.
grateful, my lords. And just
That's
one
all.
request, my lords, I believe, because when I went, case diary has everything that what he's doing after getting an interim order, after giving a statement, he's not joining, he's not at his
We'll
place,
see
my
that
lord.
from the case diary.
Grateful, my lords.
We'll see that from the case.
Lordship, a submission is made that I'm not cooperating in the investigation even after my statement is recorded. Lordship, in my additional affidavit, Lordship, from page 104 to Lordship, page 108, photograph is there. In fact, Lordship, day before yesterday, I was called in the police station and I've been asked to submit certain documents on 30th of April. So I'm completely, Lordship, cooperating with the investigation.
Case diary would reflect that, my lords. I have a full.
Okay, we'll pass the order.
Okay.
Yes.
Grateful, my lord.
Maybe Lordship 438 application, my lord, 3 petitioner, accused petitioner, my lord. One Amjad Ali, two Habibul, and my lord Asia Bibi. During the pendencies of this, my lord, 438
In this case,
application, my lord,
Lordship submitted.
Amjad Ali already arrested, my lord.
Huh?
During the pendency of this.
Who was arrested?
Amjad Ali, my lord.
Accused.
Petition number 1, my lord.
Petitioner accused 1.
Petition
Amjad arrested.
arrested is, my lord, already reflected in the earlier order, my lord.
Okay, then
Thereafter, my lord, he Amjad Ali approved his regular bail application.
He has
After
been granted.
filing the bail application, my
He
lord,
has been granted.
granted after charge sheet, my lord.
Yes. Now what about the others?
Other, my lord, accused petitioner 2 is the son of the
There is no interim?
no, my lord.
No interim, my lord.
Okay.
Petitioner number 2 is the son of the Amjad Ali, and petition number 3 is the mother
Not
of the
necessary. All
Amjad
these
Ali.
things are not necessary.
My lord, my humble submission, my lord.
You wanted anticipatory bail.
Here
There
is the, my lord, and trial court and my lord, till then, my lord, he may be protected, my lord. Already, my lord, kindly see the order, my
Not
lord.
till then. Any interim order?
No interim, my lord.
No interim order.
No interim.
This is an application under so and so, so and so. In the meantime, the investigating officer, after completion of the investigation, filed charge sheet being
10/24, dated 28 to 24.
under any section? No.
Section.
2024. Full stop. During the pendency of this petition, petitioner Amjad Hussain was arrested and he was granted Amjad Hussain, son of Bahaz Ali. Here you have written as Amjad Hussain to the incharge Tamarar, Amjad Hussain alias Ali করেছে দিন। You have written as Hussain. Okay, was during pendency, Amjad Hussain alias Amjad Ali was already arrested and subsequently was released on bail. Be that as it may, in view of the filing of Sarjit, present bail application stones close with a liberty to the petitioner to approach the learned court below for seeking regular bail. In the event such application is filed, shall be considered as per law.
Then, my lord, on all the 15 days, I will appear, my lord.
Yes, next case.
But 3 years, my lord, old age lady, my lord.
Ask why, which we can permit. Yes.
Lordship, already charge sheet has been issued.
Charge file.
Submitted. No?
Interim is there. Interim is there. Search it, interim. Disposed of.
CS number 138/24 dated 8/3/24.
Yes.
Fine.
25, my lord, case diary not received. Petitioner is in interim, my lord.
Interim case diary not received when?
On, my lord, 17th of May. My lord.
17th.
Obliged, ma'am. 26.
Interim granted, Lord.
Huh?
Earlier interim
In
granted.
this case, my lord, search sheet submitted. My lord.
Is there any interim earlier?
Yes, Lord.
Search sheet being
67/24 dated 23/4/24.
23/4/2024. Disposed of.
Obliged.
Mr. Talukdar,
Maybe after some.
just wait a minute. You can do the injunction hearing. Today may will not be possible. We'll fix a date. Okay?
Actually, after sometimes.
Why?
The scenery is another court.
Well, CD not received, my lord. In this case.
Interim is there?
Interim
When?
1 and 2 is there. My lord.
When?
My lord, on 15th of May.
15th of May. Interim order dated 4/4/24. Likhi diva specific. Yes.
28.
My lord, case diary not received.
When?
Interim was an
No interim.
my lord, on 10th of May. My lord.
10th of May.
29.
May please, Your Lordship.
Yes.
438 application, my lord. Charge sheeted matter. FIR, my lord, is at page number 18.
FIR page
18.
18.
18, my lord. My lord, the allegation, my lord, is of section 304B. My lord, the petitioner is the first wife of accused number 1, Sagar Ali. They got married in the year 1999. Thereafter, my lord, what happened? The Sagar Ali's brother, he died. And to look after the brother's family, he had to marry the wife of his brother. Who is the second wife, my lord, and who is the victim, my lord? Hajara Khatun, my lord. So, my lord, the allegation in the FIR is there. Last line of page number 18. And because of the greed for the said landed property, on 16/6/2018, at around 10 p.m. at night, the below name accused person assaulted Hajra Khatun, causing injuries to various parts of her body. So that is the allegation. However, my lord, Hajra Khatun died due to consumption of pesticide, my lord. That is in the FSL report at page number 57. So, my lord, the petitioner, my lord, is the first wife, and my lord, she has already endured enough trauma due to the second marriage, my lord. So, my lord, and regarding, my lord, the status of absconder, my lord, she is a mother, and she never absconded. She was there, my lord, and police never approached her. So, when charge sheet was submitted, she came
This
to
is
know.
by the first wife.
Yes, this is yes, petitioner is the first wife. So, Kuri Khatun, accused number 2. So, my lord, later appear, my lord, she will face trial.
Now, what is the stage? Omitted.
Appearance.
Cognizance has been taken, Lordship, and it is fixed for appearance of the
Appearance.
present.
Before the sessions.
No. So,
Before the
Chief
com-
Judicial Magistrate.
Have you gone through the case diary?
Lordship.
Any search on her?
Yes, Lordship.
Where show us that?
Lordship, search several times attempt has been made to.
Anything reflected in
Yes,
the case
Lordship,
diary?
it is
Where is
reflected.
that?
I will mark it, Lordship. Lordship, before that, may I point out two or three things, Lordship? Lordship, the FIR is of 2018. The victim died in the year 2018, Lordship. And Lordship, she was actually the wife of the elder brother.
Oh, we know that.
Yes. And
Elder brother died, so
the
maybe
younger brother-
from, maybe for properties whatsoever.
Yes, yes.
The brother-in-law married her as a second wife.
Yes.
Subsequently, she died. Allegation is that she was beaten up by these two,
Lordship.
and on the way in the hospital when she died, she was brought back.
Yes.
According to him, FSL report says that it is only for the
Poisoning.
death of poisoning.
Lordship.
Be that as this is not important. Important is whether she was searched.
Lordship.
We will not go to the merit of this case.
Lordship.
If she was searched, police could not, then we cannot help her. As simple as that.
Lordship, police searched. Summons has been issued. She has not appeared till date. 2018 matter, Lordship.
No,
Now,
during you have declared as absconder.
Yes.
police has
Police
declared
declared me as an absconder.
That is for that we want to see
Lordship,
when she was from the case diary.
Lordship,
That she went to that so and so
Lordship.
place, her house was searched, she was
Lordship.
not available.
Lordship.
So was that, we'll decide it.
Lordship, in respect of anticipatory bail, Lordship, now the case has already been cognizance, Lordship. They are seeking anticipatory bail, Lordship. Lordship, what Lordship has stated is correct, Lordship. Only thing, Lordship, I will not rely on those statements, but there are two 161 statement of village neighbors, Lordship, who have seen on that date, Lordship,
No, that will come in the second stage. That will
Yes,
come in
but
the second stage.
just
His first ground that I was not even aware. Then we'll see on the basis of that. Now, her statement was not recorded
no,
because,
Throughout the
because,
investigation.
so let
Yes.
us see first that.
Lordship,
If that is there, you go through it.
Lordship, after some time, Lordship.
Monday.
Okay.
The learned public prosecutor pressed some time to go through the case diary to find out whether the petitioner, whether during the investigation, the petitioner, the investigating authority searched the petitioner to arrest her and to go through the other materials collected by the IO against the present petition. We'll see that.
Highly of it.
May I please, your lordship, Sashited matter, my lord. LCR was called for, my lord. FIR is at page number 11, lordship.
Yeah, please, then I will.
Yes, what is the stage of the investigation?
It is my lord, appearance stage because my lord, his head is absconder, my lord. He could not be arrested before the search statement. And several attempts were made to apprehend him. That has been reflected from the LCR, my lord. Flag mark. my lord.
What is your name?
Sobiul Haqaq, my lord.
Sobiel.
What to do?
Reject,
Reject or withdraw?
reject.
Reject. The present application is filed under section 438 of CRPC, granting pre-arrest bail to the petitioner. The petitioner is a search-sheeted accused in connection with PRC case number 1137/2023 under section 120 within bracket B/376 within bracket 1/506 IPC, pending in the Court of Learned Subdivisional Judicial Magistrate Dhubri, arising out of Fakir Agans PS case number 87 or slash 2023. The case is fixed at the APRN stage. Full stop. The petitioner has approached this court primarily on the ground that during the course of investigation, petitioner was not searched by the investigating authority.
No.
However, finally, he has been sent for trial and so he was searched and sent for trial. Showing him to be absconder. Full stop. Therefore, he is entitled for grant of pre-arrest bail in as much as he is not involved in the case. Full stop. This court called for the case diary as well as scan copies of the orders, records of the lower court, trial court. Full stop. Peruse the same. The aforesaid material discloses prima facie materials against the petitioner in as much as searches the house of the petitioner were searched by the investigating officer in presence of witnesses on several occasions. However, he was
witness.
not available accordingly. Therefore, the contents of the petitioner that his house was not searched and he was not aware of such proceeding do not find favor of this court. Accordingly, the present petition stands rejected. Mr. Dr. and Mr. NNB Chaudhuri, we'll take your both the matters after admission instead of sitting because we'll sort matters, we'll finish it up. Ultimately, more or less, we are entering into the merit.
Second.
We'll see.
Well,
After. You can have your cup of tea in the meeting.
May I please, your lordship?
Yes.
So as per office method, notice has been not answered and neither it is back with. As per office method dated 23/4/24. Notice has
What is
been-
the issue here?
So lordship, respondent has filed a divorce petition in the civil court. So after that, the petitioner has filed.
Serve to Dusty.
Lordship.
Dusty. Okay. The present application is filed assailing judgment and order dated 16 to 2023. 16 to 2023. Awarding maintenance. Isn't that it?
Yes, lordship.
Or not awarding, that is interfering, isn't it? Where is the award? Page.
Lordship.
Agreed by. You want more or what?
Not lordship, or the maintenance is accounting for judgment dated. So petitioner is seek it maintenance may be accounted for filing dated.
Come on, you took order dated Swensu. Full stop. The grievance of the petitioner is that the award of maintenance ought to have been with effect from date of filing of the complaint and not from the date of judgment. Full stop. Though notices were issued to the respondent husband, however, neither ID card nor unserved notice has been received back by the section till date. In view of such report, the learned counsel for the petitioner pressed for and is granted to take fresh steps and also steps to Dusty. So should be rated to so upon the respondent number 2.
Sole respondent.
Sole respondent. Yes. After 4 weeks. Yes.
Matter came for my lord.
consideration of the IA, my lord, for suspension of sentence. My lord, the sentence is 4 years under 354, my lord.
4 years under
354 SI, my lord, and 4 years RI under section 8 of the Procedure Act with fine. So he is behind the bar, my lord, for 310 is the date of judgment, my lord. And more than 6
what is the period of sentence total?
4 years, my lord.
4 years.
4 years, my lord. In both count, 4, my lord. RI and SI, my lord. So, my lord.
Where is the LCR?
LCR, my lord, I have not gone through.
Go through it. No problem on that.
So, my lord, before judgment, during trial, he was in 3 months jail. So about 11 months, my lord, out of 4 years, my lord, he has 11 months, he is already in jail. A 32 years married person, my lord. Out of land dispute, my lord, in actually this happened, my lord.
Go Thakur, go through it. Our statements are consistent. Go
Yes.
through it.
But after
You want a we'll decide finally.
after 4 days, my lord, without any explanation of the delay, my lord, after 4 days, and my lord, I will,
After 4 days, a minor, you
Costco case, my lord.
my lord, I will.
don't go further
My
so
lord,
that we start dictating. Mr. Bhattakur, go through it.
IOS statement.
Bhattakur wants to go through it.
Oblige.
Yes. Other PW1 statement is also my lord, required is annexed with the petition. my lord.
Let his anxiety be over.
Yes, ma'am.
Instead of waiting without getting a result passing 4 years,
Yes, ma'am.
he have the confidence that yes, I can go to Supreme Court.
After some time, ma'am, I will-
Not after, next week. Next week
Next
thereafter.
Yeah.
Mr. Bhattakur, learned counsel submits that he may be, or you would like to file an objection? No.
No, my lord.
4
already,
huh?
4 years, ma'am.
Bhattakur, learned counsel for the learned additional public prosecutor submits that he would like to go through the depositions of the prosecution witnesses so as to assist this court so far relating to grant of bail to the petitioner during the pendency of the appeal. So prayer is allowed.
14.5, my lord.
This matter on 14.5.
Yes.
এটু হয়ে গেল মোটু ঠান্ডা হয়ে গেছে
May I please, your lordship?
Yes.
Please and I to impede to respond in your lordship. As respondent number 2 and 3, your lordship. What is the subject matter of the criminal revision petition is a rejection of a Jimma prayer of a vehicle, your lordship. And the vehicle, respondent number 2 is the registered owner of that vehicle, your lordship. And registered number 3, subsequent owner, purchaser of the said vehicle.
That
your
we
lordship.
know. But what about the impediment? Because in a revision petition, we cannot decide because you'll have to give it to the registered owner.
Yes.
There is an order on 21/11.
Yes.
It says that Planet Council for the petitioner prays that she may be granted some time to implead the registered owner of the vehicle in question as party in the independence proceeding. Prayer is allowed.
Yes.
Least after a week.
Hasmut Ali is the original owner.
So if if Hasmut Ali says that yes, I hand it over,
Yes.
we'll say that give learned counsel for the petitioner prays for further 10 days time to file an application in terms of this, application in terms of this court's order dated 20, in reference to this court's order date, not terms, 21/11/2023.
DNA report decided,
Yes, what is this?
My lord, on the last occasion, the DNA report of the fetus had been called for me. I don't think,
Yesterday, I have again received the updated case diary, but DNA report not yet received by the IE.
What is the issue here?
My lord, the case of 376.
No, what is the main AB?
Yes, my lord.
my lord, we are objecting to the AB and we have filed our IA for cancellation of the interim protection provided.
FIR is at page
No,
13.
FIR is page 13, my lord.
AB at what stage?
Interim is there.
No, AB at what stage? It is
Investigation,
in a search investigation stage.
investigation stage,
Search sheet not yet submitted.
Then why it is listed in the orders column?
because of
Because
our
of the IA.
IA.
What is your IA?
Lord, our IA is that, my lord, that there is an interim protection had been provided, my lord. By taking recourse of that interim protection, my lord, some interference with the investigation had been done. And therefore, my lord, we have come before my lordship.
What kind of interference?
Interference, my lord, we have lost the FIR also, subsequent FIR, my lord. And that FIR had also been taken by the investigating officer and investigation.
That case there is there?
My lord.
And you want a forensic?
My lord, may I submit, my lord?
What is the allegation? Where is the FIR?
Page
Forget about all this IA. Let us see the.
Page 13.
Let us make this absolute.
My lord, we have an objection, my
We'll
lord.
hear you. Case
No.
the case there.
Lord, absolutely the manner in which, my lord, the case has been projected in the AB is not like that, my lord. Some photograph had been marked, my lord, and those photograph has also been annexed in this petition. And secondly, my lord, after the, my lord,
Who are you? You are the
I am the
victim or
victim, I am the victim, my
victim
lord.
or the husband?
No, I am the victim, my lord.
No, application is filed by the victim or husband.
IA has been filed by the victim, my lord. My lord, may we peruse from?
I have trademarked 164 statement also in the first portion.
164.
My lord.
What is the stage of investigation, Bhattacharya?
Investigation almost substantially progressed and about to be already only waiting for that DNA report. my lord.
Even in one writ petition, my lord, my lordship was pleased to call for the, my lord, that the DNA report, my lord. Connecting with the same case. This is a clear case of rape, my lord.
Some photographs is also available in the case.
These statements are recorded, whatever.
Yes, my lord. Record.
When the incident occurred?
My lord, according to them, 8/4/2023 and 6/6/2023,
8/4.
they have filed 2 FIR, my lord.
Okay, I must answer the question. What was the date of alleged incident?
My lord, 8/4/2024, my lord.
20?
They filed this FIR, my lord.
8/4?
8/4/2024 and 6/6/2023.
My lord, FIR lost
4/20.
8/4/23 and 6/6/23,
Two different dates.
two
6/6/23.
defendant mentioned in the case, FIR.
FIR, my lord.
Bothakur,
Yes,
incident took place on 8/4/2023 and 6/6/2023.
as per from the contents of the FIR. my lord.
Huh?
Yes.
From the from their statement, her
Yeah,
statement.
Her statement.
And some third person also misbehaved. That is not a subject matter.
Yes.
Now, medical examination was done after 2 months.
Yes. My lord, actually what happened from the entire case diary, my lord, there was admittedly some photographs is also, there was some relationship between both the.
No, relationship will not permit one person to rape others.
Yes,
That is,
yes,
that is for sure. If it
I-
is a consensual, that is different.
Yes.
Now, I need an explanation. On 8/4/23 and 6/6/23, this is alleged rape.
Yes.
Okay. And fresh injury of 24 hours prior to the incident detected on 22/8/2023.
Because my lord, FIR is lodged on 28/23.
Understand?
Yes.
Forget about. When she was raped on 6th of June 2023, last raped,
Yes.
FIR was lodged on 28th of
28/23 after
20,
Yes.
28th of August 2023,
20.
when she became pregnant and
Pregnant,
whatsoever.
yes.
Now she was medically tested on 22nd of August.
Yes.
And doctor's opinion is that injury in her private part, fresh, of 24 hours is found.
Yes.
And in nowhere, in no statement of her, there is any allegation of anything after 6th of June. What is this?
Thereafter, my lord, in this case, my lord, one writ petition was also filed
Hmm.
regarding for termination of that pregnancy. My lord. Thereafter, my lord, as per the order of this honorable court, my lord, already that, my lord, pregnancy was terminated, and as per the direction of this honorable court, that fetus is, my lord, preserved
Hmm.
for, my lord, DNA test.
Hmm.
Thereafter, my lord, blood sample of the, my lord, accused persons was, my lord, taken, and thereafter, my lord, now that DNA report not yet received, my lord.
Now, why you need his person?
Because, my lord,
Because of the objection.
Yes, my lord,
That you want to be in jail.
Yes.
No, my lord,
Why
the-
custodial interrogation is necessary at this stage, Mr. Bose?
my lord, in a such type of heinous crime of rape. And secondly, my lord, the manner in which this person is not even.
We
my
have
lord-
serious doubt.
My lord,
Let us not express anything in the bail order.
no, my lord, it is up to.
See, no,
It is up to
see,
my
we are,
lordship, my lord.
no, it's not up to the lordships.
My lord.
We are not lords to decide whatever we want.
My lord.
So don't say, I do not like this word, up to the lordship. We can decide on the basis as law permits, on the basis of material law
My lord,
permits.
that is
Now,
absolutely.
the doubt in mind, see,
My lord. My lord, one thing I have been instructed, my lord, there was a relationship, a good cordial relationship was there.
no, that I have made it clear.
My lord.
Even in a love relation,
My
if it is against the will or concerning the married life, these are being said. This is not an issue. Issue is 8466, two incident.
My lord.
One is in the month of April, other is at 6. Okay, still we can accept this that Indian lady, she may not like to disclose what has been done.
My lord.
That is fine. But on 8th August, fresh injury of 24 years, we have serious doubt on this.
No, that is a multiple, my lord, multiple attempt was there on me, my lord, multiple.
No, multiple attempt was there on last on 6/6.
My lord. No, that,
We are in August.
that fresh injury is, my lord, by the medical report.
So therefore, all this gives us a doubt,
My lord.
and we do not think this interrogation is required.
Exactly.
Third, learned counsel for the petitioner also heard Mr. Bothakur and Mr. Learned. The present application is filed. Swenso. This court, under its order dated Swenso, granted interim protection to the petitioner. Accordingly, the petitioner appeared before the IO and recorded his statement. In the meantime, statement of the victim under section 164 was recorded. Statement of the victim under section 161 and 164 of CRPC was recorded. She was medically examined. Full stop. The fetus she was carrying was aborted, or what do you call it?
Removed.
Removed.
No, terminated.
Terminated, and blood sample of the petitioner has been collected, and the fetus has been preserved for further investigation. It is submitted by Mr. Bothakur that the aforesaid fetus and blood sample has been sent for DNA sampling, and the investigating officer is awaiting for such report, and after receipt of such report, the search sheet could be filed in as much as investigation has already been completed. This court also perused the case diary produced, peruse and the materials and the materials available, full stop. Perusal of the material as discussed here in above, and the stage of investigation in the considered opinion of this court doesn't warrant custodial interrogation of the petitioner at this stage, inasmuch as during the investigation, the petitioner has cooperated in the investigation. Full stop. Though Mr. Bhuya, learned counsel submits that the petitioner has threatened the
victim as well as the husband.
Victim as well as the husband, and an FIR has already been lodged. What about that FIR?
Regarding that FIR, my lord, initially filed by the my lord from the case that it reveals that a day after later on, my lord, that FIR was withdrawn.
No. That is a different one, my lord. We lost this on 5/12/23.
FIR has been lost.
My lord.
Oh, yes, my that is
FIR has been lost. Full stop.
Lord,
Now, where is this man posted?
Lord, in the informant, my lord.
Not informant, accused.
Accused, I think, in the state of Jammu and Kashmir.
And you are?
I am also in the same state, my lord, but in the different sectors, my lord.
Both are again sent there to Jammu and Kashmir.
My lord.
Full stop. In the meantime, the petitioner and the husband of the informant were transferred out of Guwahati, and both are posted outside Guwahati. Considering the matter in entirety, this court is of the view that the petitioner, this present petition deserves to be allowed. Accordingly, same stands allowed in the terms and conditions. Accordingly, the interim order passed earlier, that it so image absolute, with a further condition that the petitioner will not try to contact either of the informant or of the victim by any means, including telephone, social media, etc.
My lord.
I told you 30%.
My lord, my objections, as I have given the objection.
Yes,
that's why
we'll record that
My lord.
later. Okay.
My lord.
Why 34 same?
My lord, two accused were there, my lord.
Oh, that other. This is a different.
Same case.
No,
Same
FIR.
Okay. Common order pass kar
Obliged.
I saw this in view order pass I discuss. Case diary be returned back. কিমান আছে আৰু অৰ্ডাৰ কেইটা শেষ কৰিলো
Number 35.
Yeah, please, your lordship. The service is completed.
Your Lordship, I'm appealing for respondent number 1, your lordship.
Huh?
I'm appealing for respondent number 1, your lordship. We have filed the wakalat number yesterday, your lordship. But it is not come in the record.
Okay. You want to file an objection or you want to concede?
Yes, your lordship.
You want to concede or you want to file an objection?
Your lordship, we have objection because it is
So
a
being on
regarding.
record, what you want to object, why you want to object the transfer?
Okay, your lordship.
File an affidavit. Learned counsel appearing on behalf of the sole respondent submits that they have.
Two respondent.
Two respondent.
I'm respondent number 1, your lordship. Second is the state.
Okay, respondent number 1. Respondent number 1 submits that they have entered appearance yesterday only by wakalatnama and will require weeks time or 10 days time. 10 days time.
2 weeks time.
2 weeks time to file an affidavit in objection or opposition objecting the prayer of transfer. Full stop. Prayer is allowed. Release this matter after 2 weeks.
That may be fixed.
Give a date. 14th of May.
Okay.
Any interim order?
No.
None appears for, yes.
Yeah, please, your lordship. Lordship, this is a criminal appeal, your lordship. The judgment is page number 21, your lordship. This is the criminal appeal against the conviction, your lordship, under section 304 part 2 of the IPC, your lordship. Now the sentence was, the imprisonment was for 10 years, your lordship. Now, your lordship,
This I will file objection.
Yes,
my
10 years.
10 years.
your lordship, kindly before 14 May, because the 14 May also MSCT case has been fixed, your lordship, where the appellant is a claimant, your lordship. And the appellant meet with an accident, your lordship. And one MSCT claim was there before the Nagaon MSCT tribunal, your lordship. And for the cross.
There are provisions. Even if from the jail you can depose, you can go there. There are many provisions under law that cannot be taken. When, Mr. Bhattakur?
On
Okay,
the
give us a
22nd of May.
22nd of May.
Before that, your lordship, it permits, lordship.
Before that.
So confident.
Well, before that on my.
Before that, then we'll have to pass an order. You will have to be released. Then you will have to go and depose. Many ifs and buts are there. 22nd.
Yes, 22nd.
Mr. Bhattakur, learned counsel submits that he would like to file an objection in the IA. Accordingly, press for an adjournment. Prayer is allowed. List this matter.
On 22nd.
on 22nd. Yes.
May please, your lordship. This
Yes.
will come up next week, lordship. There are some.
This will take item 37. What you want?
Next week, only, lordship.
Next week. This is IF for what?
I for some development, lordship, subsequent development. That is.
Okay, on the prayer of the learned council for the petitioner, matter stands adjourned.
Lordship, in time order may put.
Interim order pass earlier self-considered.
Obliged.
That matter
My lord.
will take after the admission matters.
Lordship,
Okay. Huh?
Lordship, I'm appearing for respondent number 8, Lordship. Matter may be passed over to the Lordship next week, Lordship.
Why?
Mr. K. Burua will appear in this case.
Who will appear?
Mr. K. Burua, Lordship. And
Okay, okay.
Next
Next week. On the prayer of the learned council for the respondent number 8, matter stands adjourned and be listed on next week. It's a part hard matter otherwise.
Hard matter.
Next week or thereafter?
My lord, next, because they said that they have no, this my lord has to
Huh?
decide on law.
1st of May.
My lord has stated about the section, it's not.
yes,
For
yes,
yes,
we have-
there is one provision under section, even I have gone 9 also, 9(2). They,
You just
yes,
prepare this note and inform Mr. NNB Chaudhary.
my lord, I will do. Then, my lord, interim orders are there in both the cases.
Interim orders parts are will continue. We have said until further order.
No,
Until further order.
must oblige, my lord.
60.
You too. Same.
Same. Action
Same.
by-
Same.
action
These two are.
oblige.
61.
This will take after the admission matters are over. That matter, POXO.
POXO.
Yes, will take up. It will take some time. Now key is then admission classment হৈ যোৱাৰ পিছত orders কেইটা মতে কি বুলি কয় এই দুটা লাগে yes Mr.
No, 30, item 38.
Huh.
It was to be heard. And it was heard by 2 benches earlier. By Mr. Saikia and Justice Hakuria.
Huh.
No, it will sometime, let it fix after 7th. Anyway, this order may be kind of seen. Whether
No, I have seen this order.
they are
Yes, sir. What you say? Okay, we'll come back.
Petitioner and responded to our cousin by relation, my lord. There was
But
certain.
what about the other case? There are cases and counter cases.
Counter cases, my lord. Other case, final report has been filed, my lord.
Other cases.
Other
What is
case.
that statement?
Statement, my lord. My lord, subsequently, my lord. Subsequently, my lord.
Okay.
During the pendency of the, my lord,
Do
petition.
you know that any number of the final report? Lakshmi Narayan. Bothakur, all cousins. All cousins.
I am for the respondent number 2 here, man. We
Uh-huh.
have immediately settled in this.
You are the victim,
Yes.
isn't it?
Yes.
Dispose of.
My lord.
My piece of siding. Lakshmi Narayan.
Yes, well, otherwise, my offense is there.
Offense, yes,
376 is also
is
there,
there
so
means
my
because-
objection is there. Man.
If you object, we will not dispose it.
No, otherwise,
See,
Yes.
here is a case, allegation is not that kind of allegation. We know that because other cases, that's why I have asked, where is that other case? Where is the statement? Where is the recent judgment? Where 376 was,
I don't know. My lord, enlighten me, my lord. I will note it down too.
We are here to do everything, do lawyer's job,
My lord.
do deliver judgment, isn't it? Why you require your presence then? In a recent case, I think not yet reported. very recent case where a 376 in such kind of a situation
Yes.
was taking recourse to other, but I think you
Haji
Lalit,
Iqbal, my lord.
you Lalit, 376 was
Was my lord here. Haji Iqbal, my lord.
you Lalit,
Not reported, but my lord.
not reported. Give it. I think that is the case. This is the judgment. Where is the paragraph?
But affair in my lord, I have only one copy, my lord.
Yes, paragraph 12 and 13. It will be something different, a little bit different. Disposal.
Oblige, my lord.
But you will not get the order this week, next week. 40?
One.
Yes.
Password burden matter for timely.
No time being business. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 10 days. Yes.
Yeah, please, Your Lordship.
Yes.
Lordship, my lord, in this case, my lord, the wife has filed in a 125 proceeding before the court below, my lord, in the year, my lord, 2021. And their marriage was solemnized in the year 2013, my lord. And during the pendency, the case is still pending, my lord. During the pendency, my lord, she filed in another petition for interim maintenance, my lord. And against that, my lord, I am before your lordship.
The application was filed then?
Thereafter, we have filed an objection, my lord.
Okay, then.
And after hearing the objection, my lord, the learned court below has passed the order of 4,000 and 2,000. And whereas my contention before your lordship, my lord, I was in the 2018, my lord, I succumbed to a cardiac embolic, my lord. And thereafter, my lord, every business might shut down, my lord. And I am at the behest, I was surviving at the behest of my sister and brother-in-law. And I have categorically mentioned in the objection, as well as I have also submitted the medical documents, and I have also submitted, but there is no any reflection regarding my contention made before the learned court below, my lord. Now, only prayer before you, my lord, lordship, that still 125 proceeding is pending. Evidences are going on. So let the matter be finished before the learned court below, my lord. Because, my lord, I have no sources of income. I have submitted the entire document. 75% disabled, my lord. I'm a completely bedridden, my lord. I mentioned in my objection as well as before your lordship, my lord. And at the behest of I am surviving at the behest of my sister and brother-in-law, my lord.
Not at behest. With the support.
With the support, ma'am. So, my lord, that is only the condition, my prayer before your lordship, my lord. Let the matter be finished before the learned court below, my lord.
But she is not before us.
She is not before us because this notice has been served, my lord.
Notice has been served. Our condition is bad. Why you not asked you to deposit an amount once again here?
I have submitted the medical documents also, my lord.
Where is your objection before the learned trial court?
My lord, objection, my lord, at page 41, my lord. Annexure 4, my lord.
Page 41.
Page 41, my lord. Para 3, my lord. Para 3, my lord. That with the knowledge of the first party and second party, husband has sustained severe cardiac embolic stroke, heart attack on 8/11/2018. He is almost on a bedridden condition. He cannot even talk, walk, hear, or see properly, and even he cannot write or sign. Presently, he is under the treatment of Negrin Shillong. The second party husband has no sources of income, and he is completely dependent upon his sister, brother, and mother for his regular, huge, expensive treatment as well as for his maintenance. Knowing everything very well, the first party wife has most illegally and inhumanly instituted the instance case. The facts of such an acute illness of the second party husband is also found at the time of the cancellation of the instance case. Though the second party husband has no income at all, but the second party husband is sure.
Where is your medical document?
My lord. Medical document, my lord, start from page 50, my lord. Sorry, my lord, type copies start from page 48, my lord.
Have you annexed all this before the learned court below? No.
My lord,
There is no statement. Where have you given? These were not part of before the learned trial court. How can you interfere?
my lord, it was submitted, my lord, perhaps, my lord.
Perhaps what? Perhaps.
Sorry, my lord.
Can you decide on perhaps? This is in first thing, it's an interlocutory order. You are in a revisional jurisdiction.
My lord, my lord. Sorry, my lord.
Nothing is there.
My lord, kindly allow some time to take inspection, my lord, whether they have submitted the now.
On the prayer of the learned counsel for the petitioner. Matter stands adjourned. List after 2 weeks.
Can you fix a date, my lord?
No.
My lord, date?
No.
Oblige, my lord.
Undo. Come on.
Standing item number 15.
My lord, an important question of law arises in this case. Now, the petitioner, my lord, he was an IPS officer. Now, a case of a disproportionate assets case has been registered. Now,
What is under silence? Just the first
order framing charge, madam.
order framing.
Now, that order, I will briefly indicate, my
Yes,
lord.
yes.
There is an order of the Madras High Court as well as of Kerala High Court, where the Honorable Madras High Court and Kerala High Court has held that in case of disproportionate asset cases, Section 17A sanction is not required of the PC Act. Now, my lord, interestingly, a coordinate bench of this Honorable Court also, my lord, in another case has taken the same view. But my lord, all these benches, my lord, have failed to take note of one aspect. That is, my lord, for example, the Kerala High Court, my lord, they have taken note of the fact that Section 17A is perimeter to 197. Therefore, applying the principle, they said it is not required. What was not noticed by the Kerala High Court and the coordinate bench of this Honorable Court was, my lord, in case of Section 17A, even to start an investigation, you need sanction. Whereas in case of
one is not necessary.
no, not it is only at the stage of cognizance.
Cognizance.
Therefore, the Honorable Supreme Court, my lord, in Chandrababu Naidu's case has said that there is a distinction. So you cannot apply. As a matter of fact, my lord, whether Section 17A is attracted in PC Act offences, my lord, there is a difference of opinion of the two honorable judges of the Supreme Court. Now the matter is before the larger bench. So therefore, my humble submission would be, I'm trying to run away from the facts. I can argue the case. But let the Supreme Court decide the matter. Then, my lord, the issue be
Just
undertaken.
tell us, that case is in Chandrababu Naidu's case.
Yes.
Chandrababu Naidu's case, what was the issue?
Same, my lord, disproportionate assets case.
No. So far relating to Chandrababu Naidu's case, I think subject
Plus misappropriation.
No, subject to what you say,
Yes.
subject to correction, my understanding, the issue primarily was whether in the year 2021.
Yes. The retrospectivity and prospectivity. No, that aspect is there. But my lord,
fundamental issue is
no, and the Justice Aniruddha Bose, my lord, has clearly held it is required. And Justice Bella Trivedi has said it is not required.
Required in terms of the fact of that case that it is an investigation 21.
If a lordship would kindly I've already given one copy, my lord.
Chandrababu Naidu,
Second file you received. Two file, my lord, second file.
Because
Okay.
prior to that, Yashwant Sinha's case, Supreme Court has clearly said is required. Now, para 28, my lord.
Para 28.
Yes. Now we shall examine the legality of a proceeding which is started without.
Just a minute.
I'm sorry.
28.
Para 28.
Now.
Yes. Now I shall examine the legality of a proceeding which is started without complying with the requirement of previous approval under section 17A of the Act of 1988. In case of Yashwant Sinha versus Central Bureau of Investigation, who is director, a bench of this court comprising 3 honorable judges, while dealing with the power to review, had also examined this question. The bench was unanimous in rejecting the review plea. In the concurring judgment, one of the judges, K.M. Joseph, held. In the year 2018, the Prevention of Corruption Act, Amendment Act, was brought into force on 26/7/2018. Thereunder, Section 17A, a new section was inserted which reads as follows. Now, after quoting my lord, please come to para 117 of the quotation part. In terms of Section 17A, no police officer is permitted to conduct an inquiry or conduct investigation into any offense done by a public servant where offense alleged is relatable to any recommendation made or decision taken by public servant in discharge of his public function without previous approval inter alia of the authority competent to remove the public servant from his office at the time when the offense was alleged to have been committed. In respect of the public servant who is involved in this case, it is clause C which is applicable. Unless therefore there is previous approval, there could neither be inquiry or inquiry on investigation. It is in this context apposite to notice that complaint which has been filed by the petitioner in writ petition so moved before the first respondent CBI is done after Section 17A was inserted. The complaint is dated 4/10/18. Para 5 sets out the relief which is sought in the complaint, which is to register an FIR under various provisions. Para 6 and 7 of the complaint are relevant in the context of Section 17A, which reads as follows. We are also aware that recently Section 17A of the Act has been brought in by way of an amendment to introduce the requirement of prior permission of the government for investigation or inquiry under the Prevention of Corruption Act. We are also aware that this will place you in a peculiar situation of having to ask the accused himself for permission to investigate a case against him. We realize that your hands are tied in this matter, but we request you to at least take the first step of seeking permission of the government under Section 17A of the Prevention of Corruption Act for investigating this offense, and under which the concerned authority shall convey decision under this section within a period of 3 months, which may, for reasons to be recorded in writing by such authority, be extended by a further period of 1 month. Therefore, the petitioners have filed the complaint fully knowing that Section 17A constituted by a bar to any inquiry or investigation unless there was previous approval. In fact, a request is made to at least take the first step of seeking permission under 17A of the Act of 2018. Writ petition was filed on so-and-so and complaint is based on non-registration of the affair. There is no challenge to Section 17A. Under the law as it stood, both on the date of filing of the petition, even as of today, Section 17A continues to be on the statute view, and it constitutes a bar to any inquiry or investigation. The petitioners, therefore, themselves in the complaint request to seek approval in terms of 17A, but when it comes to relief sought in the writ petition, there was no relief claim in this behalf. The same view has been reflected in so-and-so. One point which has been urged in relation to the authority is that this was not a contention raised by the parties in the judgment of Yashwant Sinha and was not dealt with by the majority opinion. Hence, according to the respondent, a concurring opinion could not be a binding authority on a point which has not been dealt with by the majority. Mr. Rohtgi relied on a decision of this court in so-and-so on this point. The ratio of decision would not apply in the context of the judgment delivered in the case of Yeshwan. As in the later authority, majority view does not reflect any discord over the concurring view. Anyway, my lord, this paragraph is regarding when minority view or concurring view. In any case, my lord, when the majority did not get bill, that will be the view of the bench.
It says
So, my
that
lord-
when majority, it's a concurring, it will kind of a merger with the main view.
Had it been a case where majority would have taken a different view, it would not have been a concurring, it would have been a minority view. So therefore, if your lordship will kindly come to the next page, I should not distinguish between the main judgment and the concurring view and isolate the reasoning contained in the concurring opinion and hold the reasoning contained in the main opinion only to have the status of a binding precedent. The concurring view is just as much a part of the opinion and will be a binding precedent composite with the majority view. The position of law would be different if the majority view had expressed either directly or by implying a contrary view. This is not the case so far as the judgment in the case of Yeshwan Sinha is concerned. Hence, this principle of law contained in the concurring judgment would constitute precedent, even though it was expressed in a concurring judgment of the learned single judge, which the majority members of the bench have not differed. Thus, the steps against the appellant under Act of 1988 ought to be invalidated as the same did not commence with prior approval as laid down under Section 17A of the 1988 Act. My lord, in fact, my lord, the Kerala judgment as well as the coordinate bench judgment of this honorable court, that was a case of trap. And Section 17A itself exclusively excludes, my lord, trap cases. Where it says is not required. Then, my lord, this is the view of Justice Aniruddha Bose. Then, as far as view of Honorable Justice Bela Trivedi is concerned, my lord, para 67.
Just a minute.
Yes.
What was the concurring view? Where do you get that?
No, of
That's
which, my lord?
paragraph 117.
Of my lord?
Of the, on the basis of which the conclusion thus is arrived at. Thus, the steps taken against the appellant under 19 Act.
No, my lord, in what had happened in the Yeshwan's case, my lord, that PC Act to apply. Sorry, that permission is required. That was the view of the concurring view of Honorable Justice K. M. Joseph.
Is it somewhere reflected in paragraph 1117 or what?
117.
117?
Yes.
Yes.
In terms of Section 17A, no police officer is permitted to conduct any inquiry or conduct investigation into any offense done by public servant where the offense alleged is relatable to any recommendation made or decision taken by the public servant in the charge of his public functions without previous approval inter alia of the authority competent to remove the public servant from office at the time when the offense was alleged to have been committed. In respect of public servant,
We'll see the ratio in this judgment first.
Yes.
Later on, just we'll keep in mind.
Yes.
Further you proceed.
Yes.
So, your argument on the basis of this view is that this is one view is that it is necessary, and the other view is that
not
it is
necessary.
not necessary.
Therefore, my lord, the matter has been referred to a larger bench. Therefore, my lord, Supreme Court is yet to crystallize the law as to in respect of 17 other PC Act offences, whether 17A would be attracted or not.
There are another judgment by these two judges on
our
this
High Court,
point.
my lord?
No, by Aniruddha Bose and my lord Judge Ladyship Bela Trivedi.
Anyway, my lord, to the best of, anyway, we can lay our hands to that.
Yes. I think so. On this point.
Saying that it is required or not required.
Yes.
Required.
It is required. Maybe in a different context is started. We'll deliberate on this. Interesting topic. You get
Yes,
this
yes.
kind of cases
Yes,
in
I
a
also
while
found
only.
it very interesting.
Yeah. So you proceed. We'll start the hearing.
Yes. Now please come to para 67, my lord, for the view of Honorable Justice Bela Trivedi.
Just a minute.
Even otherwise, the sentence starts with.
And writing. Yes, proceed, you
Yeah.
proceed.
I'll have your lordship's kind attention to para 67. The sentence starting with even otherwise, has your lordship got it?
Yes.
Even otherwise, absence of approval before conducting any inquiry or investigation into an offence alleged to have been committed by public servant, as contemplated in section 17A, would never be the ground for quashing the affair registered against public servant or proceedings conducted against him, more particularly when he is also charged for other offences under IPC in respect of the same set of allegations. As stated earlier, there are other important facets contained in section 17A, like whether the alleged offence is relatable to recommendation made or decision taken by public servant or not, whether such recommendation or decision was made or taken in discharge of his official function or duties or not. Such facet could be examined only when evidence is led during the course of trial. The alleged act which prima facie constitute the offence, though done under the purported exercise of the official function or duty, could not fall within the purview of section 17A. The protection sought to be granted to a public servant under section 17A would not be extended to this act, which prima facie we are not in the charge of his official functions or duties. Any other interpretation would certainly tantamount to scuttling the investigation at the very nascent stage.
Just that judgment, that Karnataka case, State of Karnataka Lokaयुক্ta Police versus Sube Gaura.
Oh.
Appeal number 1598 of 2023.
My lord, I'll respectfully submit one thing, my lord. The view which Honorable Justice Bela Trivedi has expressed in para 67.
This was decided on 3/8/2023. Because another facet, I think they might argue regarding the prejudice of non-sanction in terms of the provision
No,
of
my
that.
lord, the legislative mandate is you can't even start investigation without this. There, my lord,
Suppose
perhaps
that is done. What will be the effect of that?
the effect will be, my lord,
19
no,
section
since the
19
language is no prosecution will start. Therefore, my lord, the provision itself provides my lord, the follow.
PC Act.
Section 17A.
PC Act.
So there is my lord, mandate that without this, they will not even investigate, they will not even proceed.
Just for our knowledge.
Necessarily, my lord, whether any consequence is provided or not. No police officer shall conduct no police officer shall conduct any inquiry or investigation into offence alleged to have been committed by public servant under this act, where the alleged offence is relatable to any recommendation made or decision taken by such public servant in discharge of his functions or duties without previous approval. Now, please come to that proviso, my lord. Provided that no such approval shall be necessary for cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. So, my lord, legislature has expressly excluded a particular kind of cases. So, had it been the intention to cover other cases, my lord, the proviso would have said so. So, therefore, my lord, if your lordships would kindly come to para 18 of the judgment, where, my lord, the distinction between 17A 197 has been called out by the Honorable Supreme Court. Of course, in the judgment of Aniruddha Bose, my lord, para 18.
Just a minute, just a minute. Certain thing, I'm a little bit confused. 18.3.
I think, my lord, that judgment is in the context of section 19.3.
Now, will there be any impact upon this case
My
of
lord,
section 93?
19.3 is a stage after investigation is over. For taking cognizance, it was at that stage. It's something akin to maybe 197.
Okay.
So, my lord, this is an additional safeguard which has been brought in. So, therefore, my lord, this has to be given a very liberal meaning. Sorry, I mean a very strict meaning.
Okay. You want to say this is under sanction under 19 subsection 1.
And if your lordship will now kindly come to paragraph, my lord, 73 of the judgment.
Paragraph 73 of the judgment. Okay.
As we have expressed opinion taking different views on interpretation of section 17A of the Prevention of Corruption Act 1988 and also its applicability to the appellant in the subject case, we refer the matter to the Honorable Chief Justice of India, the registry to place the papers before so and so so and so. So, my lord, therefore, to rely upon a Madras High Court judgment which is bereft of any reason as to why section 17A is not applicable. Even Kerala High Court, my lord, they have brought in the concept of 197. They could not have. In fact, my lord, in Aniruddha Bose's judgment at para 18, the distinction between 17A and 197 has been clearly brought out, my lord. And in fact, they know, my lord.
How this Belayam Trivedi's judgment deals with Jaswanta Singh? Paragraph 66.
Nahi padha, no? Para 66, my lord. The judgment in the case of Yashwant Sinha relied upon by Mr. Salve also would not be of any help to the appellant. Salve has relied upon the observation made by the Honorable Justice Joseph in his concurring judgment, which according to Mr. Rohtogi was a discordant note in variance with the main judgment of the two honorable judges. Be that as it may, what has been observed by Justice Joseph is that section 17A constitutes a bar of any inquiry or investigation without the previous approval of the concerned authority. Said observation nowhere states that section 17A shall operate retrospectively or retroactively. And it was an additional facet which was involved in this case, where in our case it is not applicable.
Because that was not necessary. That is well, because this was fundamentally that issue was after inquiry was started, after amendment.
And on the day when the matter was decided also.
That was the issue in Chandrababu Naidu, I think.
Yes.
So we'll go on the merit of this own case, whether sanction is required.
No, my lord, my humble submission would be, if your lordship reaches a conclusion, there are two ways of looking at it, my lord. Either
we'll decide what is law holding the field.
Okay.
I think that is, otherwise everything will be stalled. There are judgments of Honorable Apex Court which is only reference will, this is the two opinions only.
No, at least on section 17A, my lord, there is no other decision other than this. Yashwant Sinha is already there, it says it's required. Even if we disregard, my lord, Chandrababu Naidu's case, Yashwant Sinha is there. It says
Says
it's
Jaswant says,
and my lord, in
is
this,
can it be a view that says Jaswant Singh
yes,
being a conclusive judgment,
Yes.
holding the field,
yes,
will be binding upon us?
yes. No, my lord, here in this case,
I'm saying,
correct,
it's
correct.
binding
No,
upon us.
no, here in
Will
this
not depend upon when the outcome
of the Supreme Court.
Supreme Court comes. We'll
Yes,
decide.
reference, yes. No, but here in this case, the state was aware that it is required. They have taken from state government, whereas I am an IPS officer, they should have taken from central.
Okay,
government.
that is another facet. Okay.
And secondly, my lord, an IGP level officer should have referred the matter, where in this case, a DSP has done it.
Okay,
These are the two other facets.
So let us proceed from the facts.
Okay. My lord, for some better clarity, would your lordship take sometimes in the next week, my lord?
No problem.
I'll come up with some more preparation, my lord, since your lordship is.
Public proceedings.
No issue.
After hearing.
But your lordship rightly point out, the Chandrababu Naik is the opinion, it's a view, not a judgment.
I remember one judgment, forgotten it. There was an issue so far relating to that hospital, whether hospital is within the industry.
Okay.
There are 3 judgments pending, long line of debates and.
I think in the context of some act, it is yes, in some
Yes.
context of some
So
other.
ultimately, Supreme Court says that yes, hospital is
Is an
in the
industry.
interest of workmen's, all this industrial dispute act, it's an industry. So industrial dispute act, private hospitals, industrial dispute
Will be covered.
will covered. Now that view, after so many years, that view has been, there is a difference of opinion, is matter is pending before a larger bench. So we confronted with this. There are some judgments.
No, my lord,
which-
there are judgments of the Supreme Court which says merely because the matter is referred, it's not that everything will go on limbo. Therefore, whatever law is holding on the field, that should govern the cases.
Yes.
But there are also 1 or 2 cases where, my lord, it has been said that we should await. But the preponderance of judicial
Then
view seems to be.
question of await in certain cases may be permissible,
Maybe.
but in certain cases
May not
where
be.
the object of the act is to complete the trial within 2 years, even 19(1) says sanction will not interfere. So in as a whole context, we have not made up any mind, but these are the, I think, important issues. to be discussed.
2 তারিখ না দুই তারিখে বহুত কেস আছে my lord, today is 24th না 5th 7 তারিখে লাও নাকি ভাইয়া হাত থেকে
I'll not come on 7th.
no হাত থেকে let it be on 9th, my lord.
9th is it?
Oh. My lord, could it be on 8th, my lord? 9th, I am told there's a full bench. 8th, my lord.
8th. Hard. Mr. Chaudhary, I want to keep it as a part-head. Because I want to
Only thing is,
want
my
your
lord,
deliberations.
6th is the day before the trial court. Possible exam our appearance on 6th.
Already interim is there. Already interim is there.
Already interim.
So in the earlier interim order will continue.
Okay, that will definitely continue. Mr. Hard, Mr. K.N. Chaudhary, learned senior counsel, who argued at some length and seeks an adjournment to rely on certain judgments and to elaborately advance his argument on the next date fix. Prayer is allowed. List this matter on 8th for further argument of Mr. K.N. Chaudhary and reply argument of Mr. Fukan, learned public prosecutor, special public prosecutor. List accordingly as part heard.
Earlier interim order.
Interim order, pass earlier shall continue.
Deeply.
I can allow it. 7th or I got Agdin. Yes, Mr. Burwa.
My lord, as per office note, my lord, 22(3), my lord, the service is complete, my lord. So may I pray, my lord, it may be taken up after 2 weeks for admission, my lord.
Okay, this matter pertains to
Quashing of, my lord, proceeding, my lord.
passing of proceeding.
Yes.
Office note dated 22/4/2024 reflects that service has duly been effected upon respondent number 2. Accordingly, the scan copy from the scan copy of LCR has also been received. Full stop. Accordingly, list this matter
15 May, my lord.
on 15th of May in the admission column.
Please, Your Lordship. This is 482 application, my lord. Passing of an order dated passed by learned session judge in connection with bail application 07.
Item.
44, my lord.
Yes.
I'm appearing for the respondent number 2, my lord.
They have
Yes, what
already
is the
applied.
issue here?
Passing of an interim order, my lord, passed by the learned session judge in connection with bail order arising out of Manja PS law, my lord, 44. It's a setting aside of direction of a session judge, my lord.
Page 22 is the interim order.
You are for
For the petitioner, my lord.
And for the informant, my lord, respondent number 2.
file a writ petition.
My lord. We have already stay, my lord.
Stay of what?
Against this interim order, my lord.
But from the order sheet, it appears, my lord, already the IO has been changed in pursuant to this order.
Okay.
Now.
So IO has been changed. Rest is initiate departmental proceeding. We'll examine it. That's all.
This for hearing, my lord.
Huh?
It come up for admission, my lord.
See, this is for, see, we'll not fix it for hearing. Issue
Only-
is,
only-
where are
on-
the statements? We want to see that court has said that
Statement of one.
statement of one victim. If victim implicated,
One George. George's name appeared in 164
Appeared.
statement.
okay.
George is not examined by the IO. That is
IO.
that.
Why not
the
examining?
issue.
In the meantime, George has been examined. We may,
would
we may not, we may allow him to do with a liberty to the department if so advised. That may be a judgmental error also. We cannot decide that. Court ought not to have decided straight away. He ought to have asked.
Raises here whether the learned session judge, my lord, exceeded his power.
I think so that he has exceeded. He could have made a recommendation that in view of this, the employer may examine and may proceed departmentally if so advised. That could have been, because somewhere you'll have to give strict also. But he has exceeded that.
We have placed a judgment, my lord.
But Apex Court has also said, my lord, the court cannot direct the IO to investigate
In
case in a particular
because
angle.
subsequently that person may be 313 or something, 300, where it can be made an additional as an accused on the material 319. That power is also there. Everything is there.
There are also.
Lordship, admission.
As the more service complete.
Okay, learned
Question right.
counsel for the
Admin.
respondent number, you are for?
Respondent number 2, my lord.
Respondent number 2 has entered appearance today. Accordingly, he seeks some time to seek some time. Prayer is allowed. Please this matter.
Yes, no objection in admitting the appeal. Perhaps it is not admitted yet.
Not admitted, but if we admit, it will go long.
My lord, it can come up for admission hearing, my lord. on
We'll
that day it can
decide
be
it.
decided, my lord.
After 10 years,
Well,
the judge will
lordship.
say, see, this judge has admitted this matter. And we are taking up after 10 years.
Because otherwise, my lord, there are also judgments which say that if prima facie the court finds that there has been an error on the part of the IO in conducting the investigation, it's deliberate, then he can direct departmental proceeding. That precedent is also there, my lord.
Direction is it's a job of, I think, of the employer. He can give an opinion that he has not conducted properly. You may proceed against him, may. So then they will see whether they may say so cause he may give an explanation.
Yes.
Then they may drop the proceeding or they may continue with the proceeding. So straight away departmental proceeding direction is not the.
We'll try to satisfy your lordship. We'll fix a date. We'll satisfy.
So suppose under discipline and appeal rule also, a so cause is issued to him. Then so cause he gives a clear satisfactory. Then employer may think, okay, he has satisfactory reply, therefore we'll drop. But court has given no option for that.
Or the court could have itself asked him,
Ask
why
him
did you
to
not
so cause that.
examine?
Why have you not recorded?
We'll examine.
We'll examine, definitely. But But in these cases are not that much of urgency. Already I will send.
I will say.
Now, Mr. Das, you have a scan copy of the case diary.
Scan copy, my lord.
Scan
Uh,
copy is
scan
still
copy,
there, I believe.
in case that is not there. But we have to produce, perhaps it is not submitted. New case, my lord.
So therefore,
not
scan copies will relate whether court was correct in deciding that.
Yes, sir.
That is also important. We cannot say, he may argue that yes, this is done, we'll have to verify from the case.
If
diary.
scan copy has been received, my lord.
No, no, scan copy of LCR, case that is
Yes,
not
the
there.
LCR
There is
was-
Only LCR.
In the meantime, Mr. Das, learned additional public prosecutor, shall produce the scan copies of case diary of
Manja PS 44, my lord.
Manja case number 44 of 2020.
Let it be original case that, my lord, because.
Okay, okay.
yes, sir.
A case diary of Manja police station case number 20.
My lord.
Deeply obliged. Lord.
Yeah, that did be a case diary, no? Mr. Das will give you a date because it's a calling of case diary. 28th of May.
May I please, your lordship?
Yes.
The petitioner is before your lordship, praying for recalling, my lord, the non-available warrant of arrest, my lord, issued against the
You-
petitioner.
Why you did not appear?
Because, my lord, here were as many as 21 accused persons, my lord. And in the meantime,
I don't know what you did. I see. You appeared, then stop appearing, or you have been declared as absconder?
my lord, I appeared.
Then what is the reason of non-appearance?
Non-appearance is that, my lord, here were 21 accused persons in this case.
Mm.
All of them were family members and relatives. my
Mm.
lord. And somebody was appearing, my lord, and in the meantime, the present petitioner, my lord, he also amicably settled the matter outside the court, my lord, with the informant, my lord.
Mm.
So that, my lord, some other accused persons were appearing, and he was supposed to be represented by the, my lord, the engaged counsel, my lord, but that was not done, my lord. So I was on the bona fide belief that, my lord, my attendance is not requiring. And therefore, my lord, even the police was
You
also,
annex the compromise.
no, my lord.
Then
The other side has entered appearance, my lord, and
I'm for respondent.
notice was issued, my lord, and
file an affidavit.
it is there, my lord.
File, lordship.
Affidavit
It's
file.
74, yes, lordship.
Okay, we'll come back after.
My lord.
Yes.
63 to 73. The instruction not received, Lordship. Can you fix the date in the next week?
So you cannot wait. No, nothing doing. This habit has become bad. After 3:30, nobody is here.
Item number 41, my lord.
Yes.
Date may be fixed, my lord.
Okay, give a date item.
Item 41, my lord. Nine, 10th of May.
With your lordship,
Hmm.
that I may be given one chance, my lord, I will regularly appear before the learned court, my lord.
Okay, we'll give you a chance. Hard.
A. Ali, my lord.
Mr. A. Ali, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor on behalf of respondent number 1. And Mr.
A.K. Azad.
A.K. Azad, learned counsel for the respondent number 2. The present application under, when is the next date fixed?
Next date, please, my lord, 26/6, my lord.
26 lagi rakho, ha? The present application under section 482 of the Code of Criminal Procedure 1973 is filed with a prayer to quash and with a prayer to set aside and quash impugn order dated 17/8/2019, impugn orders dated 17/8/2019 and 9/2/2021, and all subsequent orders thereto passed by the learned Chief Judicial Magistrate Dhubri, issuing non-bailable arrest of warrant in connection with GR case number 4365/2014 arising out of Fakirganj PS case number 277/2014. Full stop. The case of the petitioner is that the petitioner regularly appeared before the learned trial court below till
My lord, I appeared only once, my lord.
initially appeared
Miller.
before the learned trial court along with 20 numbers of accused,
20 numbers.
20 numbers of accused. And he was supposed, as he had some personal difficulty, he was supposed to be represented by his law. A prayer was supposed to be made to represent true lawyer, and he was under mistaken belief that he was being represented by the lawyer. However, subsequently he came to learn that he was not duly, no such application was filed, and accordingly the NBW was issued. Full stop. The petitioner contends that he has no intention to avoid the trial and he is ready and willing to face the trial, and henceforth he will regularly appear before the trial court when the matter is fixed, and therefore the non-bailable warrant of arrest should be interpreted.
My lord,
The learned counsel for the respondent number two submits that the accused and all the accused in the connected case,
only the present petitioner.
the present petitioner and
Informant.
the informant, present in petitioner and informant / respondent number 2 are relatives, and they have already entered into a compromise settling the dispute between them. Be that as it may, in the considered opinion of this court, the petitioner should approach the learned trial court below seeking a recall of the NBWA issued earlier with the explanations as given in the present case, or with NW or with some additional explanation that he may give. And on such application being filed, learned trial court should consider the prayer made and explanation given in the given facts and circumstances of the present case. Full stop. Accordingly, the present writ petition stands disposed of. Oh, sorry. What to do, Mr. Present with criminal revision petition whatsoever, it stands disposed of with a direction to the learned, with the direction to the petitioner to appear before the learned trial court below on or before the next date fixed, that is on or before 6/26/2024 with appropriate application before the learned trial court below. On such application being filed, the learned court below shall consider the same in the given facts of the present case and pass a reasoned order in this regard. Till then, the NBW, the non-bailable arrest of warrant issued against the petitioner shall remain suspended.
Lord, white order dated 29/1/2024. PNA was also issued.
No, NBW and PNA issued.
I'm obliged.
Yes, sir.
Let's see, your lordship.
Yes, somebody said.
Well, the learned PP 6 time lordship to go through the facts of the case.
Yes, whatever you want to sometime. Huh? Yes.
So, my lord, may submit, my lord.
Yes.
Lordship, in the year 2022, lordship, some ereckaners were seized, lordship, from my house as well as my uncle's and my brother-in-law's house, lordship, on the allegation that those are of Burmese origin. Lordship. Subsequently, lordship, I have filed one application for Jimma of those articles.
This is item number?
Item number 62, lordship, supplementary. Lordship.
Okay.
So subsequently, lordship, learned JM first class lordship called for the report, lordship, and accordingly, page 58 and 59, lordship, those are the certificates issued by the agriculture officer Kachar, lordship, certifying that those are of Indian origin, lordship. And accordingly, lordship, the learned JM first class by order dated 9/5/2022, lordship, allowed my Jimma petition in favor of me, lordship. Then thereafter, lordship, the state filed a criminal petition before this honorable court, lordship. And after, lordship, prolonged hearing, lordship, this honorable court referred the matter, again remanded the matter, lordship, before the JM, lordship. And
where is that?
That, lordship, order, lordship, I have annexed, lordship, page 102, lordship, is the operative portion, lordship.
Yes.
So the trial court shall pass appropriate order depending on the stage of investigation. They are currently also
Okay,
directed.
okay, understand. Yes, next.
Lordship. Thereafter, lordship, I have filed an again application before the CJM, lordship. And accordingly, lordship, by the order dated 31/7/2023 at page 104, lordship, the Jimma was again allowed, lordship. Then, lordship, that after taking that order, lordship, I appeared before the IO for releasing those articles, lordship. Along with that, one letter, lordship, that I will not use it for human consumption. For industrial purpose, I will use it, lordship. But that was not complied, lordship. Again, I informed the lordship, learned JM first class, lordship. Again, on 7/9/2023, lordship, the JM first class by
Then what happened? Finally, it was not complied with. Then you are agreed by which order?
My lord, your lordship.
But
that
8/1/2024.
Those facts, my lord, which now he stated, my lord, those are at the time of filing 451 application. Now present impugn order is at page 128.
That is what I want to say. Final impugn order.
So final order 128, lordship, impugned order, lordship.
8/1/24.
By which the CJM, lordship, modified the all earlier orders, lordship, passed by the learned JM first class. So JM first class.
How the CJM is under what?
No, he has not modified his earlier order as because in view of the division bench order of this honorable court during.
Where is page 28?
128.
128 is the impugned order.
Annexure 28.
On the basis of a letter, lordship.
In fact, my lord, CJM also allowed his prayer by putting certain conditions, my lord.
Now CJM is, lordship, saying that I would ascertain my ownership. Although, lordship, earlier I have produced everything before the honorable court, and on that basis, lordship, the learned JM first class allowed the Jimma, lordship.
Now, what is the problem? Giving you the ownership document. That is with you.
Yes, lordship. I have already produced it, lordship. But after these 2 years of keeping those articles, lordship, in their custody, lordship, now they are saying that your lordship may kindly come to page 131, lordship.
Yes.
Their lordship, now they are saying that it appears that the seized consignment were loaded in different vehicles. Although those lordship seized articles are seized from my house, lordship.
Where is that?
Page 131, lordship, second para, lordship. The learned CJM held that it appears that the seized consignment were loaded in different vehicles. Completely different, lordship, saying, lordship, after 2 years. So in these 2 years, lordship, nobody claimed, lordship.
So final order is that according to the petitioner Anwar Hussain Laskar,
yes,
with directed to appear before the OC Dholai PS with his documents for verification and assert his right over the seized property.
Yes, Lord.
Apart of that, who is the under get poison says shall dispose of the PS shall dispose it on the following condition. Okay, condition will come to the bank guarantee, that is later on. Now, what is your problem in showing the owners?
Condition number 3, lordship.
Condition number 3 will come.
The Jimmadar shall not dispose of the seized
Okay,
terracotta
that will
without
come.
prior.
That is not a problem. Forget about that. Dispose of is another question that we may allow. There is no problem on that. 9 lakh also we can allow. But what is your problem with the other furnishing your
No,
ownership?
I have no problem, Lordship. I have no, even
Then-
Lordship, I have produced it along with this petition, Lordship.
Before this honorable court, by way of this criminal process challenging for quashing of that order. My lord, where is the illegality in that order, abuse of the process of the court, my lord?
No.
Now, my lord, learned trial court, my lord, at that point of time, he is placing those facts which were, my lord, argued at the time of filing 451 application. Thereafter, all these new
What is that
developments, my lord.
subsequent order that's why I have adjourned.
Now, my lord, they will have to
I
approach
passed
before
a
that.
subsequent order. Where is that?
That order I have not taken, Lordship, but I have available it, Lordship. 588 of 2023,
No, my
Lordship.
lord, if now the IO has not released after verifying those documents, they will have to place their grievances before the trial court. That after,
Not, IO has, I think he has no problem. His problem is that 9 lakhs and non-disposal.
Lordship, criminal petition 588,
yes, my lord,
2020.
interim, my lord, Jimma was granted in their favor till definitely, my lord, if no ownership is not yet ascertained as per that order.
No, without
Then,
ascertaining
my lord,
ownership, how
then-
can you give a Jimma?
Yes, my lord, otherwise, my lord, my lord, CJM has also directed the IO to ascertain the ownership and thereafter putting certain
Two
conditions.
aspects are there. Already once ownership was ascertained, thereafter direction was given. That is one aspect. For the timing, we are not going back to that. There is an order. Okay, fine. He is ready to give his ownership.
Yes, that
No
might-
problem.
then no problem.
But this 9 lakhs and not to dispose of.
Yes.
Keep the recanat with you. Don't dispose it of at your cost.
Because, my lord,
Don't dispose it of.
Yes.
We are giving you custody, you maintain it.
Yes, Lordship.
Don't dispose it of.
I may be
because otherwise, my
compensated.
lord,
Then
earlier,
what will he do with the undisposed?
yes.
You take the sample of arecanut. Or you will exhibit whole truck of arecanut before the court.
My lord,
Be
difficult-
practical.
Yes, my lord, understand. Well, otherwise, my
And
lord,
you are also, I have adjourned this case, we have spent 15 minutes only for that judgment, because we have laid down the principle, whether it is 451 or 456, the principle of law is same. Application may be 450 and 456.
Yes, Lordship.
So
that-
this, to support, in support of your case, we have said you just bring that order.
Lordship, actually,
Actually what?
I-
Actually, we are adjourning this.
yes, sir.
On the prayer of the learned counsel for the petitioner, matter stands adjourned. Will not see like that. Adjourn and list this matter after 10 days.
My lord, on Tuesday may kindly be.
No.
listed, Lordship.
No. Indulgence to a limit is good. Not beyond that.
All right.
If you are not sincere to the cause of your client, then your client will face this.
My lord, I have annexed the division bench judgment, Lordship. But
What the
that,
division bench says?
Lordship,
Division bench context is totally different.
yes.
Division bench context, it relates to at what stage, which application. Is it a subject matter of this
Today
case?
morning, Lordship, I'm searching, Lordship, earlier, Lordship, but today morning I got it, Lordship, and that order, Lordship. So kindly, my lord, if a date may kindly be fixed, Lordship, so that I can, Lordship, take a printout, Lordship, or after some time, Lordship, if your
16,
Lordship
5 minutes.
permits, Lordship. Otherwise, Lordship, I will suffer, Lordship.
That's what to do, tell us.
Or after some time, Lordship, I will take printout of that order, Lordship, and produce before your Lordship. I have already available it, Lordship. Otherwise, my client will suffer, Lordship, because since last 2 years, more than 2 years, Lordship passed, Lordship.
This is not the order, Muslim. It is one of the, but main whole determination was that state of Assam appeal. That series matter.
Yes, 284 criminal petition, 284/22.
That state of Assam, not by the division bench.
Yeah.
After that, another petition was there where Mr. P.N. Goswami
Yes,
argued the matter.
your lordship has.
Here I delivered a
Yes,
judgment.
your lordship has further approaching before the trial court.
Trial court, but
and-
what should be the parameter in giving in either of the cases? We have interpreted both Sundar Bhai Ambala and division bench judgment.
Yes, my lord.
That
And-
is what I want.
Okay. Okay, my lord.
That Mr. P.N. Goswami argued that
Yes,
series.
my lord, I can.
In our mobile, it is there.
Well, I will provide one copy, my lord.
Okay, when matter is when?
On Tuesday, on 7th of May, my lord.
Possible, Musu?
Oh, my lord, on 15th of May, my lord.
15th of May. Yes, what are all this?
Lordship, the 107 notice was issued to the petitioner, Lordship, for peace and tranquility by the circle officer, Lordship. It is Samuguri, Lordship, and they challenge regarding the notice which was sent to them. They stated that it is not accordance with the provisions of 111 of CRPC, Lordship, where it is required that an order should be passed before issuing the notice, wherein to show the bond amount and as well as the complaint which is initiated on the basis of the complaint. That is the requirement, Lordship. But the honorable court sought for the instruction, Lordship. Instruction yet to receive, Lordship.
Very much to consider, Lordship. Annexer A is the impugn notice, Lordship.
What is this order at page 18?
Page 18 is from Lordship, Kerala High Court, Lordship. I took support from this, Lordship. And our court also, Lordship, in item 66, I have annexed, Lordship, has stated the portion. It's a cyclostyle, Lordship, notices. Only MR case number is different, Lordship, same notice.
Now, what to be done today?
Lordship, instruction sought for, Lordship, instruction.
What
received, Lordship.
instruction?
Observation was that interim will be considered, Lordship.
Yes, after obtaining the instruction. Lordship.
Where is the other order?
Item 66, Lordship.
Item 66. give it.
Page 19, Lordship, item 66, Lordship.
What do you mean?
All are same notices.
Same.
Page 19 is the interim order, Lordship.
Yes.
19, Lordship, 19, Lordship, annexer B, Lordship.
What section 111 says?
Lordship, 111.
111, Lordship, where a magistrate acting under section 107, section 108, section 109, or section 1010 deems it necessary to require any person to so cause under such section, he shall make an order in writing setting for the substances of the information received. This is the primary information received, the amount of the bond to execute, the terms for which it is to be enforced, and the numbers and characters and classes of the sureties, if any required. Now, Lordship, what they claim that these are necessary in 107 notice, but 111 stated an order is required, Lordship. Now, whether that order was passed by the magistrate or not, I have to sort the instruction. That is my case.
Okay.
Nothing reflected in the notice on that.
No, not reflection of notice is not required.
No info.
The learned state council. prays that he may be granted
Lordship,
10 days,
10 days, Lordship,
10
election.
days further time to obtain instruction in terms of this court's order dated 24/2024.
Lordship.
Prayer is allowed. List accordingly on 21st of
Observation of interim will be considered after.
but which are the cases interim orders are there? No case.
Here not,
Fine.
Lordship,
Okay.
other 7 cases.
Interim order will be considered on the next day fix. Interim prayer will be considered. Yes. All these matters up to
73, Lordship.
up to 70.
11.
All right. No. Doctor. Oh.
Timing item number 1.
I will take only 3 minutes. Appeal memo, my lord, page 25 for a once, my lord.
Page 25.
Page 25, my lord. I'll be very much short. Last paragraph, paragraph 38, my lord. Paragraph 38, my lord. I'm sure.
Mr. Das, disturbing. This is the case where that court has also made so many statements, so many observations in the judgment. Even at the time of dictating the judgment, could have recalled the. Is not it? This is a special. Anyway, next.
My lord, this item, my lord, maybe taken up next week, my lord. 3 years conviction, my lord, they are on bail, my lord.
Mostly. Dictation. What? Where is the? Yes, daughter was examined. SPW.
Perhaps PW6 body.
PW6.
6 is well. I'm not well today. I'm not well.
Don't be well. No problem. We'll take our help ourselves. We'll record your name.
What happened, my lord? The complaint was filed before the Senate magistrate. After the 1 month, 10 days of the LS incident. And my lord, the learned magistrate took the cognizance after examining the CW, my lord. It was the complaint case, my lord. And took the cognizance and found the prima facie case. And after cognizance, my lord, under section, my lord, 366 and some other section, and case was committed to the session judgment. And the learned session judge, my lord, complete the trial, my lord. I think here, my lord, actually, my lord, the delay, the main case is there at night, my lord, when the victim alleged and the complainant, they were at night, were sleeping. The 7 persons name in the FIR. They entered in the house and assault them and kidnapped the minor daughter. That is the PW6, my lord. But, my lord, the incident was taken place as alleged, my lord, on, my lord,
Doctor was examined.
but the doctor was not examining, not, she was not examined, even a person, my lord, the alleged girl, my lord, after release from the alleged kidnap, they have filed this complaint. So when 1 month, 10 days, she was under the custody of the accused number 1. He is not before your lordship, he is absconder. Main person is Rafiqul Islam. Alleged them, he kidnapped and committed the offense with her. But that person is absconded and trial was not held against him. Only the relatives, the present petitioners, appellant matter. And in this case, my lord, the mainly, my lord, the delay of filing the complaint is doubtful. And fact is that she voluntarily went to the house of the absconder accused, my lord.
Why?
And because due to love and affection, my lord, in every
What is the age of the accused?
age was found that she is major, my lord, because they has failed to stabilize the minor. The learned single judge also, my lord, the session judge also, my lord, in his, my lord, judgment stated that it is not a case of the minor because they could not produce any documentary evidence. My lord, page 105, last paragraph, my lord, that discuss about the age, man. Page 105, my lord.
What is the name of this accused?
Just accused is Rafiqul. Rafiqul is abscond.
No, your petitioner?
Yes, Habibur and
Habibur.
Habibur.
Only Habibur.
Yes,
Only,
ma'am.
now only Habibur, man. Other things are not coming.
Total here, my lord, that 6% before your lordship. All are the relative, and one is the father of the Rafiqul. Due to love and affection, she voluntarily went there. They solemnized the marriage also. And when mother demanded the land should be given in the name of her daughter, there was a dispute. She returned back, and after return back, again 6 days they wait. They lost the affair that my daughter was kidnapped on so and so date. The kidnap, my lord, if originally
Married
kidnapped,
from Rafiqul.
Rafiqul. He is absconder. He is not before your lordship. Trial is not held against him. And my lord, why if any person kidnap my lord, then 40 days nobody can wait, my lord.
We do not know. We know whatever is the evidence and whether on the basis of this evidence
Yes.
you could have been convicted.
That's right.
Or there is any doubt has been created or prosecution has been failed to prove their case.
Yes.
We do not know what 40 days should be remembered. We cannot go by those presumptions.
Yes.
Argue legally.
Yes, my lord.
Don't say all these things. Now let us see whether the evidence of PW6 is trustworthy.
Yes, ma'am.
Because PW6 is trustworthy, number one. Number two is, what is the implication by her against you and how you did your cross-examination? Whether you have second her evidence. These two things we will see and go further. Yes.
Then can we come to the PW6 mark?
Yes.
Page 27, madam. Rohima Khatun is my mother, who is the complainant. I know the accused person. It has been about 8-10 years since the incident. Around the time of incident, we were residing at number 2 Namuthi Sarkari Cycle Basti. I lived with my mother. My father was no more.
What happened to the Siddiq and Idris?
But they're the neighbor, my lord.
No, what happened to them?
My lord, Siddiq and Idris, my lord, they came, my lord, subsequently when they were shouting.
They were convicted, not convicted.
Oh, yes, my lord, the appellate here, my lord. Yes, my lord.
Mr. Das, only Habibur was convicted and or Siddiq and Idris were also convicted.
Siddiq also convicted, my lord. Siddiq Rahman alias Abu Bakr Siddiq.
And
convicted.
Idris?
And my lord, Idris also, my lord.
Then had they preferred any appeal?
Yes, my lord. They are also appellant here.
Here appellant.
Yes, my lord.
You said that Habibur is the appellant here.
No, Habibur and 5 others.
5 others. Who are the appellants? Tell us.
Page 42, my lord.
Tell us. Habibur, Siddiq, Idris.
Habibur, Rastam, Abdul Matlib,
Okay.
Rahuluddin,
Rustam,
Idris Ali,
Abdul
and
Matlib.
Siddiq.
Okay, all this.
Yes, my lord.
Habibur, Siddiq, Idris, Rustam, Rahul and Mutalib.
Mutalib is not.
Not.
Yes, Mutalib also. Abdul Mutalib here. Total, my lord, 7 persons is the complaint as accused, my lord. Out of 7, 1 is the absconder. He is the main accused.
So here, Rafiqul is absconder.
Yes, ma'am.
Habibul, Siddiq, Idris, Rustam, Rahul and Mutalib.
Yes.
They are the appellant.
Yes, ma'am.
Okay.
Now the Rafiqul is absconder. He served as the marriage, my lord. The fact is the different. Now the story is totally different now. So I am reading the page 27, PW6, my lord. I lived with my mother. My father was no more. At about 2 a.m. in a night about 4 months after the death of my father, I was sleeping with my mother inside the house. Then 7 persons entered our house by breaking the door. They broke the box and took the amount of rupees 5,700. Sorry, 70. When I intend to cry out, accused Rafiqul get me by means of his hand, lifted me and took me to jungle. The person who entered our house were Rafiqul, Habibur, Siddiq, Idris. I recognized them in the flash of torch they brought. Habibur, Siddiq and Idris also accompanied while I was being taken to jungle. Accused Rastam Ali, Rahul and Mutleb were waiting outside at the time of burglary and they too went to the jungle after I was taken there. Later on, Rafiqul and Habibur stayed with me in the jungle and rest of the person left. Rafiqul had sex with me in the jungle. I cried and forbade him, but he did not relent. After keeping me in the jungle for the night, I was taken to the house of Rustam's brother on the following day. Rustam is the father of the Rafiqul. There was not allowed to come out of the house and they kept me there for about a month, putting me under threat. Though Rafiqul intended to commit bad act to me during the period of that 1 month, he could not do so since I offered resistance. Thereafter, Rafiqul, Habibur and Rustam Ali took me to the house of Rustam Ali. There they did not allow me to come out of the house, put me under threat. Rafiqul assaulted me and told me, go wherever you want to go. want to go. After staying there for some days, I saw my mother and came back with her and then went to the house of my maternal uncle at Kaliabor with my mother. I told about the incident to the Gani, Idris, Hamid, Intas, and Fazlul in presence of my mother. My mother filed a case. I made my statement before magistrate in that case. Exhibit 2 is my statement. Exhibit 2 is and 2 is on and 2 are my signature. Around the time of occurrence, I was as it 12 and was reading in class 3. Then I was reading in Ambari school. I have not submitted the certificate of my age. I heard from my mother that I was born in 1991. I do not know if my mother obtained the certificate of my birth. I was born at Koliabor. I was born in the original house of my father. I do not know for how long we lived at Koliabor in my
Forget
side.
about all this. Who are the neighbors? Tell us. Neighbors witness. According to her, there are certain witnesses.
My lord, my case is that all the
Your case is that Rafiqul and you had and the victim had a love affair.
Love affair, she-
Both eloped.
Eloped.
And these people
Is-
helped.
is
These
40
people.
days they are
These
staying?
people helped. They stayed. Subsequently, at the behest of her mother, affair is lost.
Hi.
Now, the mother says that when there was a hue and cry in the night, some neighbors came to the place of occurrence.
Yes.
What is their evidence?
My lord, they are saying that they came.
Who are these?
My lord,
PW?
my lord, PW2. PW2 page 17, my lord.
Das. What you say?
And also just, we are going to.
Go through. PW?
PW, my lord, 2, page 17, 17.
Page 17.
Of paper book, my lord.
Page 17. Siddiq.
Yes, ma'am. Typically PW2. I know Rahima Khatun. She is my neighbor. Dilwara Khatun is the daughter of Rahima Khatun. The incident had taken place about 6-7 years back. I was asleep, having heard a hue and cry at about 2 a.m. I immediately come to the house of Rahima. I found Goni at the house of Rahima. Intaz Ali and Fazlul also came to the house of Rahima. Almost simultaneously with me, I found many people there. On my arrival, I found Rahima lying unconscious. Box of the house was lying broken. The door to the house was also found broken. When we poured water, she regained her sense and then asked about the incident. She told that the Rostam Ali's son Idris Rafiqul Siddiq and Habibur Rahman took an amount of rupees 5,070 and her daughter Dilwara away by breaking the door. I found the cloth of Rahim torn. On following day, we the village and Rahima went to the house of Rostam and when asked about the matter, Rostam is the father of the Rafiqul, that boy. Rostam abused us. Thereafter, Rahima went to the house of her brother at Kaliabor. About 1 month thereafter, Rahima found Dilwara in the house of Rostam and Dilwara came back with her. PW2 saying that he came back with her. But mother said that she was sent back and my lord, after a person voluntarily came, my lord, it cannot be in the case of my lord, kidnap, my lord, because during that 40 days, no affair is lost. Though they are saying we have lost the affair, but no evidence they could place before the complaint case, my lord. The landed judge also, my lord, said that no documentary evidence showed that they have filed any complaint or case before the police station during the period of that 40 days. Subsequently, we asked the Rahima about the incident. When came across her and she told that Siddiq, Idris and Rafiqul Habibur took her away forcibly. I made my statement before the magistrate earlier. The case was instituted in the course and I put my thumb impression there. Initially, CW was examined only for with the cognizance because it's the complaint case. Now, my lord, the CW was not closed that time. Now, when again they have appeared before the court as PW, then it was closed. My lord. So the PW part only we have to examine. In close, my lord, my house and that of the accused person share the same boundary. I am familiar with the accused persons and in speaking terms with them. The house of Dilwara is also situated near my house.
Name of this PW?
My lord, page 18, my lord, close part.
Siddiq, na?
Siddiq. In every witness, my lord, when the approach, the defense counsel but suggests that part that she voluntarily went there, marriage was summarized, and after a few days she returned back, and you have filed this false case that it was a kidnap. And if anything happened, well, that will go to the upon Rafiqul, but Rafiqul is not tried. He is declared as absconder person. During that time, the Dilwara was reading in the school situated nearby the house. It is not a fact that Dilwara is the adopted daughter of the Rahima. In fact, she was adopted also, but that is not our part. It is not a fact that Dilwara is my niece. Dilwara called me Mama. My village courtesy, Goni and Fazlul are my neighbors. The house of the Rahima is made of wooden pillars, post, thatched wall, and wooden door. Though the house of the Rostom is situated very close to mine, we did not go there searching for Dilwara.
Just a minute, just a minute. Okay, proceed.
Yes, my lord. The PW2 saying that it is not a fact that Dilwara was in love with Rafiqul and eloped with him during the day of ours. It was the suggestion, but he denied. I have no personal knowledge with the regard to breakage of the box and taking the money away, etc. He's saying that I have no knowledge about the taking the money. I came to learn it since Rahima told this to me. It is not a fact that I have deposed all the things falsely.
See, sum and substance is this. There is an allegation of kidnap and rape.
Yes, my lord.
Okay. Rape is only by Rafiqul,
Yes, my lord.
not by anybody. And the FIR was lost after a month.
40 days.
40 days.
Yes, my lord. Why did she return back?
After 40 days after her return.
Yes, my lord.
So far relating to the depositions, more particularly four persons, including 4 persons neighbor who reached the place of occurrence after hearing hue and cry.
Yes, sir.
All deposed that Rahima was found in an unconscious position. Her house was broken, doors were broken. And these are the people who she stated. So Rahima and victim's statement that you forcefully entered into the house and kidnapped her daughter even reaffirmed during cross-examination. Okay. Second part is that the persons who stated by the victim to be present in the place of occurrence reaffirm her statement, and during cross-examination also they reaffirm. So more or less the fact that you forcefully entered, you beaten them up, taken the girl away is established. Now the question is that 40 days delay.
That is right, my lord.
That is the only things is to be reminded. Argue on that.
Suppose, my lord, the person is kidnapped. with the
No,
kidnapping
no,
fine
we do not
recovered.
know, suppose
Please,
these,
now, my
that
lord,
we cannot go on
yes,
suppose.
yes, my lord, I am submitting, my lord.
You give a legal argument that
legal
these are the facts.
In case of,
Because of this delay is not explained, this delay is fatal to the prosecution. And or for this reason, there is a doubt created upon the story of the prosecution,
Yes,
therefore
ma'am.
you need
Yes,
acquittal.
yes, ma'am.
What can be done, what not
I
can
am
be done
coming,
is not a
I-
business
I-
of this court.
yes, I am coming. The
Don't argue
kid-
like a
but
repetition.
The kidnap and missing is the different thing. When a person is missing and somehow he return back voluntarily, then he can come and say and report that I was
These are
kidnapped somebody
principles.
else.
You are saying, you argue on the facts and
Just not
materials.
a kidnap, my lord. If she kidnapped, they would have been lost the complaint. Whether police suppose it was kidnapped, even then they delay. Why not when she voluntarily came to the place before the police? Directly they filed the
We do
complaint
not
case.
know why not.
My lord, a person, my lord, if claim that she is a kidnappee, then immediately.
What you say, Mr. Das, regarding this? You take your
No,
seat.
PW1 says, she lodged the FIR, but it was not registered. PW1 says.
PW1 says and PW3 also says that I went with Halima to the police station.
And normally in such cases, victims used to be not, they do not know, opt for complaint case, not here complaint case filed without having not found any other remedies.
That's why then 14 days delay, 40 days delay. Suppose police is not taking action, if
Yes,
a girl is
that
kidnapped,
that
a very
explanation.
serious incident, my lord.
Yes, yes. That
Serious
explanation.
incident,
Yes, yes.
nobody will sleep, my lord. That when she will come, then I will file the case.
Yes,
Because the house is very near.
That explanation.
Person's house and complaint house is very much near. It is the case that she voluntarily went there. Mother was crying because that night when she left the house, mother got the shock somehow. And then mother maybe cried, my lord. And the people came, she reported. And on that spot, my lord, suppose she was kidnapped forcefully, they lost the FIR. Police don't register the case. Nobody will sit, my lord, up to 40 days when she will return, because not just 5 minutes distance the house, both house. After 40 days, why the complaint case? Why not she was produced before the police? Why not her statement was recorded under section 164?
Arguments are not made this way, Mr. Counsel. Why not? We do not know why not. We are in appellate court. You say that this is the reason, no explanation is given, these are the facts.
No, that's why I'm
This
saying
is not
it is
the
a
way
false
to
case.
argue a criminal
It
case.
is a false case, madam. It is a false case, therefore they did not do this all, because the backdated they cannot do anything. Now they have no any option, because when girl returned back from the house, and what type of case they will file? They have filed this complaint case, saying a backdated false story, madam. So, madam, the main accused is the Rafiqul. Rafiqul is absconder. If something happened, that is with the Rafiqul. They are the family member. No, 75
Moment
years.
you blame Rafiqul, you are involved.
Yeah.
Except rap, you are the part of the game.
My lord, the
If
father.
you are arguing that it is the Rafiqul, it is established beyond doubt that you were you were with the Rafiqul all throughout. Matter is there.
In the case, my lord, the advocate suggests defense case is that, my lord, that she voluntarily went due to love and affection. They solemnized the marriage and they stay their conjugal also about 40 days. Somehow it was not lead long more. Then she returned back and they prepared the story by instigating of some leading person of the locality, and she was taken to the court, not to the police station. If originally, my lord, the PS case would have been filed, the learned session judge also called for the report from the police, and from the police station came the report before the court, my lord, at the time of trial. No affair was lost, no complaint was lost before us. It was only the verbal statement before the court, my lord. So the court, my lord, was confirmed that.
Mr. Das, how this delay was dealt with? Prosecution, anything?
Yes, I will come to that, my lord.
That part only.
Yes, yes. One thing, Lord, by way of cross-examination, he has given opportunity to PW1 to explain the delay. My lord, may kindly see, kindly come to the cross part of the, my lord, PW1.
PW1.
Yes. Cross part. I am a little educated.
Just a minute. PW1 page 10.
Yes. I am a little educated. As your lordship got it.
Just a minute, just a minute.
It is cross.
It will record yes, sir.
It is CW. CW.
PCW.
That is a complaint case is evident.
Complaint case, initial deposition. That has no value at
Yes.
present.
No, no, it is PW1.
No, 10 is PW1. 10 is PW1. CW is later on. CW starts at 36. Page, CW starts at page 36.
PW1 for.
PW1 starts at page 10.
32.
Yes, it
Oh.
place 13 below.
Page 13.
I am a little educated. I filed case in Shankardev Nagar Court. Exhibit 1 was read over to me. I put my signature on it. Accused Rustom is the father of another Rustom, another accused Rafiqul Islam. Rustom Ali came at the time of occurrence. In the following morning, he was at his house. It is not a when you were on legs, I did not utter a word. Please sit down. It is not a fact that I mistakenly stated in the court earlier that Rustom Ali was not at his house on the day of occurrence. After 10-12 days, my lord will kindly note, after 12-10 days of the incident, I left Cycle Basti and came to the house of my brother at Koliabor. About 1 month thereafter, I again came to Cycle Basti with my brother. I tried to go to the house of Rustom Ali, but I was not allowed. I saw my daughter in the house of Rustom. The way I stated in the court earlier, my daughter voluntarily came back with me, and then we came to the house of my brother at Koliawar and filed case in the court on the following day. Prior to that, I lost case with the PS, but the PS did not register the case. Police hushed up the case, taking bribe. I don't know if police registered the case and investigated it. I don't know if police continued the investigation after registering the case and produced my daughter Dilwara Khatun in Shankardev Nagar Court on 23/5/2005 and got her statement recorded in Lamding PS case number in.
So meaning thereby, their suggestion is that already case was registered, then it was investigated and statement was recorded. This is your case.
That is his case.
This is your case.
But session
That is
call for
the cross examination.
In judgment matter, session just call for the record. The from police station report come. No FIR was there. Because session judge also take the note of that point, because whether it was filed or not.
Then when from this Lamding PS case number 139.
Just now we get the point.
So he has brought all these things on during cross examination.
Lamding PS case number, no such case number available. And when kidnapping returned back, she was not placed before the police also. Her statement must be recorded under section 164 in case of 366 in kidnap case matter. And she was not examined medically also, madam. And a kidnappee never say that I was kidnapped. Because voluntarily come, voluntarily go. After the incident, it is not case of kidnap matter.
W3 W3454. W345. তারাই মনে হয়। তাহলে আছে নাকি? W34 or 5. Evidence. Reproduction. এটা কি এটা মনে আছে? W1 আছে 2 আছে 6 or 7 আছে। এই হেৰি নাম কোৱা নাই?
This CW1, CW2, CW3 were exhibited or what?
This is not exhibited, I think. Yeah, exhibited.
That's only part is delay.
Only part is delay. And my lord, to some extent, my lord, opportunity to explain the delay has been given by the my lord, defense itself.
Oh, no, no
By way
doubt.
of-
There is some explanation.
And one thing, my lord,
40 days delay in lodging the affair.
No, my lord, when police did not act on their FIR, it is consistent.
The report was, or has also been accepted that yes, there was no FIR.
Obviously, my lord, when police did not raise
But
that.
we cannot go by the obvious
that is
things.
correct,
We'll have
that
to
is
go by
correct.
the material available on record.
But to some extent, explanation has been given. But 10, 12
Mentally,
days,
we may be convinced,
10, 12
but
days.
on what are the materials to see the explanation? Yes, any law on delay?
But the mainly case is that fine, the story is false and delay is there, because the backdated story, my lord, was fact that she voluntarily left and she stayed with.
You are arguing something else.
Otherwise, my lord, incident was not happened itself. Because all the PW came subsequently, man. The complainant falsely reported them, my lord, only to make out the.
All your suggestion that she has voluntarily left, she was not kidnapped, are specifically denied. In cross-examination, reaffirm how you entered into the house, how you have broken, how you have taken away the money. Why are you not understanding? Arguing a criminal appeal, knowing nothing will appoint an amicus. No, sorry.
But I have a judgment also.
PW 1 and 6, my lord, are duly corroborated by PW 2.
That we have seen
3,
because the star witness is PW 1 and PW 6. And along with them, the neighbor who first immediately reached the place of occurrence.
Raise this evidence, my lord. There is no scope to, my lord, change the facts.
Yes. So
as she revealed, they have stated.
Therefore, I am submitting, my lord.
So there is this not only is the first place to appearance, and they have corroborated
each other.
Not each other. And everybody says who reached the place,
Yes.
after who reached when, and what they saw.
Yes.
Everything, whole situation is corroborated. That is the reaffirmed by the witnesses. Now only question is the delay. If delay is fatal to the whole thing, then it's fatal.
No, my lord, fine. Kidnap is not here. No case at all, my lord.
Kidnap is not here. From where are you saying?
My lord, I am saying, my lord.
You are saying not do.
They have come subsequently, my lord. They are here to witness. They have not seen when she was.
You know nothing about criminal law. Don't argue. Hearsay. What do you mean by hearsay evidence? What do you mean by hearsay evidence?
The complainant reported them, my lord. And they are on the basis of her statement, they are saying before the court, my lord. Therefore, I am saying, my lord, that the hearsay.
It is called raise this evidence.
This is called raise hearsay. This is not hearsay. That's why I'm saying you know nothing about the criminal law. Arguing, taking a case of a victim.
Sorry, my lord, then date may be given, my lord.
No, will not give you any date.
You could not explain that why.
Yes, Mr. Talukdar, come forward. On next Tuesday, paper books are there. Apparently, till now, our view is that the occurrence or the commission of offense is moral, will not say it is established. Subject to what you say, will not give our view. But only difficulty is that in FIR, in fact, not FIR, a complaint case was lodged after 40 days.
Without any explanation.
Explanations are there. And thereafter, FIR registered, then proceeded.
Under 156(3).
Yes. Now, explanations were, certain explanations given in the SIF, and that explanation was reaffirmed in the cross.
By the defense.
The first explanation is that FIR was lodged immediately. And one of the person who reached the place of occurrence immediately and accompanied to the police station also says we went and filed an FIR before the police station. But that was never registered. Now, during the magistrate call for the report, police says no FIR was no FIR.
No, it was fine.
So in that circumstances, court says that no explanation is sufficient. Okay. And he is arguing somewhere else that we cannot let him understand. He has taken a brief, let him be here. Sorry to say, generally I do not say all these words, but there is a limit to everything. So we are
Paperbook may be
appointing you as an amicus.
A copy of the paperwork may be given, sir.
Copy of evidence, photocopy, evidence of the photocopy.
No, he will give a copy of the paper, but it may be delayed. You xerox a paper, copy of the paper book. Can
So I will give the paper book.
I will give the
You
paper.
can give the paperwork.
Paper. Okay. Hard. While we want to record your incapacity. His
Mallet, morning Mallet, I have, very first I have told Mallet I could not go through the petition.
This is not the way. This is
I prayed for adjournment today, Mallet.
2000
Actually, Mallet,
2010
I'm not physically well.
Don't go further, please. As the learned counsel for a petitioner has not been able to properly assist this court has requested Mr. Talukdar, D. Talukdar, to assist this court as an amicus. Full stop. He has readily, Mr. Talukdar has readily accepted such request. List this matter on not next Tuesday, year after Tuesday. Holiday. Okay, next Tuesday. We'll decide this matter. Next Tuesday. That date to Riva as part heard. Mr. Talukdar, you also look into, we may not be
That
correct. We want your assistance only, not for the petitioner or the defense. We want your assistance. Just because apparently this court is of the view that the commission of offense is established beyond reasonable doubt. Look into.
So it will be
There
on
are some discrepancies here and there, will not say, but the three persons who reached the place immediately has corroborated what the lady has said, that she fell unconscious. They found her in an unconscious state. House was broken. She said they found house and almirah were broken. All these were, and in the cross it was reaffirmed. And how she was, girl was it was not, age was not said, how she was taken through jungle and where not, all she described. And this was also reaffirmed during cross. Cross has created much more problem. Isn't it, Mr.
Yes,
Das?
yes.
Cross is very.
And that was how going to happen in this. Therefore, I thought that I should happen. I do not want the same thing to happen here.
So it will be on 30th. 30th.
Yes.
What has come?
Pathar naki?
Just part heard,
Well, perhaps you will also may kindly see order dated 15/2/24.
15?
15/2/24.
not the last order, before that.
15 to, yes. Okay, 2023. Okay, this was heard by an coordinate bench and was kept as part heard on 15/2/2024, and thereafter matter was again heard on 23/03/2024. Accordingly, listed before appropriate bench. They thought in terms of 15 it is 1 month is over. That's why.
Yes.
But it was hard thereafter. Anyway. Yes. Next case. Who is for the appellant?
The causes was shown as R.K. Pradhan and all.
Huh?
R.K. Pradhan was
None appears for the appellant on call. Inside or outside?
inside, sorry, outside.
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 None appears for the appellant on call. This matter is pending since the year 2012 and the accused appellant is on bail. This was conviction for
420, 113.
period
3 years.
3 years. 420.
420.
Full stop. However, in the interest of justice, matter stands adjourned.
420,
Huh?
468, 419 IPC.
In view of non-appearance of the learned counsel for the petitioner, appellant, the registry to issue a notice to the accused, intimating the accused that the learned counsel has not entered appearance when the matter was called for hearing. Full stop. List this matter.
Any date in the month of May.
May. List this matter in the second week of May 2024 for hearing. In the event none appears for the appellant on the next date fixed, this court may proceed with this matter by appointing an amicus.
My presence may.
Okay, although Mr. Upor non-appeal, though Mr. So is Halloy is learned standing counsel for CBI is present. Yes. Yes, Mr. Kamar.
But there are three appeals, my lord, for and three different representative of sets of lawyers, my lord. So there is a conviction against my lord. Your lordship is kindly taking on which matter, my lord?
As far as
No, because our pagination will not tell you otherwise.
Oh, no, you tell us.
I mean, criminal appeal 151, my lord. 147, it will be or two. Criminal appeal number 147. my lord.
Yes, I'm with 147. Any paper book prepared, no?
No, my lord, there's the biggest problem. And there are 33 PWs, I believe. Kiman tha 35 or 33? 33 PW. So reading all these PWs itself.
We understand the difficulties.
Honestly pointing it out.
See, we are here to do this. We cannot shy away. And you are here to do that.
Yeah, absolutely.
You
No
cannot
doubt of
shy
it,
away.
no-
It
no
may take
doubt.
1 day, it may take 10 days. We cannot say that it is voluminous.
I don't know. I'm not using those words, but I'm just pointing it out. There are 33 PWs.
Intelligent people says things differently. At 340, we understand. Instead of having peanuts, reading deposition is difficult, but
Yes,
what
but-
to do? Now we are compelling the
We are
people.
in 330 something.
340.
Malik, just pointing it out, man. Can a paper book of only the evidence can be prepared? Rest we don't want. Paper book consists many of the
What is the
exhibits.
status of this appellant?
Appellant, my lord, actually I've been engaged, my lord.
Bank employee.
No, they are bank employees, my lord. No.
Let the bank employees prepare a paper book of the
Because
evidence.
I don't have it, otherwise I would have not asked anything. Well, if one set is given, we will do it, my lord.
There are writings in.
Suppose your lordship will not mention it in the order, if your lordship asks the bench assistant to do it for us, we'll share it, prepare it for ourselves. We'll give it one copy to him also.
I got a copy of the evidence from the appellant already, just now.
এইটো সেই ৰেকৰ্ডৰ পৰা দিলে আমি share কৰিম। Easy হৈ যাব তেতিয়া paging কৰি ল'লে।
of appeal pertains to a judgment and sentence dated thirty
2012
three zero
3007
07
2012
2007 passed in
2012
passed in
first in special case number 23 of 04
04 full stop. There are as many as
33 PWs.
33 PWs were examined by the
prosecution.
Full stop. For proper appreciation, after hearing for some time, this court is of the view that for proper appreciation of the matter, a paper book containing the evidence
only the evidence
slash deposition of the 33 witnesses will immensely help this court in arriving at a just decision. Accordingly, the registry is directed to prepare a paper book consisting of the evidence slash deposition of the 33 witnesses.
only maybe written so that wastage of
Only.
313 statement will be required. 313
And
statement.
SARS evidence and.
charge evidence and
So
treated.
SARS evidence and
And
313.
treated. That will only
All deposition of type SARS deposition and 313
Is
statement
of the
recorded. Statement of the accused recorded under section 313 CRPC. Full stop. Accordingly, list this matter in the month of June.
Yes.
2024. 2024. The first of such. Okay, we'll bear it. List accordingly. Somehow
smooth landing.
Kotoki is ready.
Kotoki is ready.
Kotoki is always ready. Now from next date we'll say who are ready. That also we tried. Then you will say nobody. That we tried in the civil bench when the second appeals of 2003-5 are pending. We are failures. Now the brothers Borua is trying to implement this. And here also till now we are a little bit failure.
Even
though
when
there is a
even when
complaint,
something is moving-
everywhere,
No,
that
at least-
court are not taking hearing matters.
No, yes, that message will be that message.
Isn't that
But,
it?
my lord, what we have come to know, your lordship is at least trying to streamline it. It's not just giving a goodbye to
Trying
everything.
and
No, at
achieving is two
least-
different things.
Okay. At least something is being streamlined, my lord.
Let us see. Yes.
Yes. It will take time, but it will take shape, my.
Yes.
This is actually, my lord, in this I also not yet disposed of, my lord. This is a appeal under judgment dated 13/9/2021, passed by Special Judge Sipsagar, my lord, in a case under POSCO, my lord, convicting the appellant under 6 and 18 of the POSCO Act, my lord. And he was sentenced to undergo 10 years and fine of 10,000 under.
He's outside?
No, he's inside.
Inside?
Yes, it was 10 years, my lord. And 5 years also for under section 10, my lord. And
Where is the Zahar page
the FIR, the paper book is also ready, my lord.
Yes,
FIR you will also find. It was lost by the wife, my lord. against the husband, my lord. That your lordship had paid phase 4 of the FI. It was lost after 70 days of the occurrence, my lord. Phase 4 of the paper book, my lord. I have to honor to state my husband, Ranu Ahmed, has been trying to molest my daughter.
Daughter, own daughter or daughter fathered by somebody else?
No, his own daughter, my lord. A long time he has been torturing her mentally by uttering various obscene words. My daughter, Miss Sabira Begum, aged about 16 years, a student of higher secondary first year. My daughter, Miss Sabira Begum, informed me on the matter on 25/4/2017. Your lordship may kindly see. He was informed on 25/4/2017, but FIR was lodged on 5/7. And at the time, my daughter and I were in the house of my husband at B2 Port. Since I am woman, I did not lodge the complaint with anybody out of fear of my husband, and he beats me after consuming liquor. And we fled to a paternal home at Ligri Pukuri following the morning, and we till date. My daughter himself will narrate the matter in details. I raised to him.
Somehow I dealt with this matter somewhere at the time of admission.
It was admitted on 2021 model. Thereafter, records were called for.
No, it is earlier.
And the charges that have been framed, my lord, that is, your lordship will find at page 6. It was framed under section 6 as well as read with section 18, that is attempt, and as well as under section 10 of the POSCO Act, my lord. And for assaulting his wife, my lord, causing her simple hurt, 323 has been framed. My lord. Altogether, prosecution has examined, my lord, the including investigating officer, my lord, there were altogether 10 witnesses were examined. The defense also examined 2 witnesses, my lord. The accused himself as well as DW2, my lord.
Why this matter is so familiar? Who did the bail
Where, my lord?
before the trial?
Before trial, bail, my lord, I cannot say exactly.
Why so familiar, sir?
He must have got at the time of investigations. It's from Sibsagar, actually.
Today we are going for final disposal or for bail?
Bail, I want to satisfy your lordship, if your lordship. Because actually, what happened, my lord? The delay could not be explained because she was immediately after occurrence, according to her, she left to her maternal home, parental home, and Ligri Pukuri. But she was not allowed to stay in her parents' house. And she roamed about to her aunt's place because our defense was that he was my wife was having an affair with her.
Some Fazal.
Fazal, yes.
Fazal.
Fazal, who happens to be the brother. And my daughter also was having affair with another girl. As a result, she tried to commit suicide, madam. When I caught all over her. As a result, dispute started. That before the lodging of the fire, I went to Ligri Pukuri to bring her back. They refused to come. Instead of coming, they lodged an FIR, alleging that I assaulted her daughter. That is a defense.
23 to punishment.
But her deposition is unsecond.
Now the question is, my lord, whether regarding that delay part.
Delay, how much delay?
More than 70, around 70 days.
70 days. The mother says that how do I inform others? He
No,
is the father.
No, no, if your lordship goes by her statement, other witnesses, she was earlier went to her parents' house. Actual genesis of the case has been suppressed. Parents, none of the family members of her parents, her brother or mother or anybody, nobody was there. They did not allow her to come because they knew something was fishy about her, correct, most probably. Then she stayed in the house of Fazal.
10 years.
Fazal for
5 years.
and thereafter, before lodging of the case, she went to a rented house.
618, 600.
So our case is that is a got up story, madam. And there are contradictions you all will find. Because whatever is Bosco cases, my lord, as your lordship law, section 29, when the foundation is laid, the court generally presume that case is made up until contrary is proved. In this case, what has happened? By way of correspondence and by reducing defectiveness, we proved that no case on the Bosco has been made up.
Foundation is late.
I understand.
Foundation is late
late.
because of the victim statement.
Statement, I understand.
Okay, fine. Suppose you have taken a defense case because you have you have made suggestion that relation with Fazal and all
Yes,
everything
my
is
lord.
there. Now, how do you prove it? Will it be possible to complete today?
It will take some time, man. Because of, but that part section 29, but court has never dealt with. Court has gone by the evidence of the prosecution. They have never dealt with the defense evidence. Not a never discussed anything.
That is to be discussed, of course.
Because when I have taken the burden myself, that I have not committed offense, these are the circumstances why I have to face the trial. At least court has to look into those aspects.
Because it's a special case.
Yes, special case.
Special case where the presumption is against you.
Yes, ma'am. If you are Justice Suman Cham Dharban is there, madam.
When presumption is against you,
Yes.
then it is bounded due. Suppose we hold that that was not there, then what is the remedy left? Will that vitiate the entire judgment?
Yeah, no, that appellate court can examine it.
That is what I'm saying. We can examine
Yes.
whether on the basis of this you
can-
could discharge your burden.
Yes, that
If
part-
you have discharged your burden, then it's a case of, it will be a case of acquittal.
Yeah, that is the thing.
But
So,
that will need some deliberation.
the deliberation will necessarily be. You have to go to the
Yes,
witness,
because-
evidence of the witnesses minutely, madam.
Minutely, very minutely. It's not like other cases.
No, no.
That we have established, these are this.
Yes.
So when
As you are subject to your lordship's convenience, madam.
we don't have any convenience.
Today is convenient.
Every day is a convenient day, but subject to Mosumi saying dates. I think this next 2 weeks is a little bit tight.
Yes,
28th of May.
Yes, sir.
Okay. Due to paucity of time, the hearing could not be completed. Accordingly, list this matter on 25th of 28th of May 2020.
Next case, my lord, recently they have engaged me, my lord.
These are new cases of revision.
Revision.
What is the issue?
55, sorry, 55.
On earlier date also, earlier appear হওয়া নাছিল না।
আগৰ ডেটটো পিটিশনৰ সাইডত নাই কোনো নে এডজাৰ্নমেন্ট কোনে লৈছিল
None appears for the petitioner on call. You are legal aid counsel.
legal aid counsel
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 2/4/2024.
I'm on behalf of the respondent number 2, my lord. Completion.
To MS BRA Sultana Learned Counsel
On behalf of respondent number 2.
is present on behalf of respondent number 2 and Mr. Watakut, additional public prosecutor, present. The present petition is filed assailing. Where is the order? Assailing an order dated 29/9/2022.
Yes, my lord. Special POSCO number 53/2001.
Passed by the learned special judge Pox within bracket POXO
Sonitpur.
in special POXO case number 53 of 20 Sonitpur, Sonitpur boli diba, in special POXO case number 53 of 2021. Where is the application for appointment and all? The petitioner what is the earlier High Court's order? Petitioner and the respondent number 2
Page 47.
are husband and wife. And the respondent number 2 lodged an affair before the lodged an affair inter alia alleging that the present petitioner had sexually molested their own 12-year daughter, and accordingly aforesaid registry will expedite the process of preparation. Full stop. Mr. Swenso, Learned Counsel, Photokia, Learned Counsel, submits that he has recently been engaged in this case and requires some time. Accordingly, matters stands adjourned and be listed
Immediately after preparation of the.
immediately after preparation of the paper.
So my case will, other case will be part hard one.
Okay, make it part hard,
Yes.
but it will, we do not know. Then if it is part hard, we have to fix it within a month. When we fix it? 38 of this method, no, earlier method. 38. This 38. Okay, we'll see on the hard in part. Okay, let us also have some taste of here and there from other taste also. Isn't it? Why should we be deprived? Next.
Yes.